ಟೈಮ್ ಆಯ್ತು ಯಾಕೆ ಹಂಗಷ್ಟು ಬನ್ನಿ. ಸರಿ, ರೆಕಾರ್ಡಿಂಗ್ ಸ್ಟಾರ್ಟ್. ಇದು ಮ್ಯೂಟ್ ಮಾಡದ ಬೇಡ.
Kotal 12 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಸರ್ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಅಲ್ಲಿ ಇರೋರು ಆನ್ಸರ್ ಮಾಡಿ. ಓಕೆ
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್?
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಎಲ್ಲರೂ ಮೆನ್ಷನ್ ಮಾಡೋದು ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ, ಅದಕ್ಕೋಸ್ಕರ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಇಟ್ಬಿಡಿ, ನನ್ನ ವಾರದಲ್ಲಿ ಫೋನ್ ಆತರ ಹಂಗಿಲ್ಲ ಸರ್. 1 ವೀಕ್ ನಾನು ಡೇಟ್ ಪಕ್ಕ ಫಿಕ್ಸ್ ಮಾಡೋದಾಗುತ್ತೆ. ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಬಿಡಿ. ಒಂದು ಸರಿಯಾಗಿ ಮಾಡಿ.
Oh, is it applicable to you? Yes, Monday. Tomorrow, I think there may be. Tomorrow it may not be reached. Monday. Tuesday. Wednesday. What is that urgency? No, what is the matter? All cases there is a stay application. Suit for partition. It is pending. RFA is pending. No, that you have not obtained any interim order. No, you are one of the co-owner or a purchaser. You are one of the family member. Monday. Yes. Tuesday. So tomorrow, I don't think there may be some benches. Yes, Tuesday. Monday, some other matters are supposed to Tuesday. Yes. Tomorrow. No, MUC matter is not coming before me. The other bench. Yes. If you are not deposited, then order will. Tomorrow. Tuesday. What is that urgent? Tuesday.
Page wise adjustment. Number 1, page number 1, serial number 1. Page number 2, serial number 2 to 5. Page number 3, serial number 6 and 7. Page number 4, serial number 8. Page number 5, serial number 9 to 11. Serial number 2. Page number 6, serial number 12 to 18. Page number 7, serial number 19 to 23. Page number 8, serial number 24 to 31.
29. Yes. At the request of counsel for the appellant, use this matter of 2 weeks. Yes.
Page number 9, serial number 32 to 40.
He has some personal convenience.
Yes, at the request of counsel for the appellant, use this matter of 2 weeks. Yes.
Page number 10, serial number 41 to 49. Page number 11, serial number 50 to 55.
55.
Maybe Shivkumar.
Yes, at the request of counsel for the respondent, use this matter 2 weeks. Yes. I think in both judgment is similar. They said that what is that compliance under 45B? A. There is no difference between two judgments. The wording, see, in that earlier judgment, they have given a detail how it should be. In the later judgment, it said that only 2 words. They said that if it is written and that there is no interference. Written filing means not just filing in a returns. It has to require. Section itself is changed. Yes, anyhow, next week. Yes, next week, at the request of counsel for respondent, release this matter next week.
Number 1 for order, serial number 1. Abhijit Arnaldi for appellant. V. Vishwanatha Shetty.
What is this matter, madam? Still it survives. Is it suit? No, suit for. Yes. What is the order? For partition is degrade. When this is entered to the partition separate. Suit is degrade. 39.5 defendant is rejected. What has happened to the suit, madam? Suit for performance. Still it is pending. You have obtained any interim order here? Then oh, that is true. Any interim order granted here? Then by the time you would have been executed the sale deed. Yes, learned counsel for. Yes. 2 weeks time is granted to do the needful.
Number 2, Saravana is for appellant.
Weeks time is granted to do the needful. Oh, yes, you do it whatever you want. Yes, you do whatever you want. Yes.
Serial number 3, Chandan for appellant, Bettegowda.
Yes. Yes. The counsel for the appellant has filed in a memo. 18/11/2022. Taking leave of this court to withdraw this appeal on the ground that suit itself has been disposed of. The memo is taken on record. The appeal is dismissed having become infructuous.
Number 4, yes for appellant. Number
Yes.
4,
Week's time is granted to comply the tax objection.
serial number 5, Median KTS.
What is the tax objection, Mr. Mehta? No, what is that office objection?
Tendency of the suit. We had the benefit of an added to stay, restraining the respondent defendant from going ahead. And the matter was heard on merits. It was posted for orders on 3/1/2023. During the vacation, 19th of December, the first day of the winter vacation of Bangalore, violation of the added to stay in anticipation of order in their favor, they hold a meeting. That view of the matter, I had to bring that on record for the knowledge of.
No, then you have to file a contempt there.
Contempt is all right. Contempt will take its course based on humans.
Hmm.
But the interim order itself survives because it was done in violation of an added to order in force. That's a nullity.
Yes, nullity, they cannot, yes. No, they, if it is nullity, they cannot enforce on that.
That is right. That is why I am before the court for a stay of action on that illegal meeting conducted by them in violation of the order of the court. I'm here for an interim stay of that order.
Now that, what is the prior in the suit?
The
What is
prior,
that?
when we filed the suit,
Hmm.
we filed the suit in November of 2022. There was a move to move the amendment with great haste. The amendment simply is this: they want to increase the age.
Now that, what is that prior in the suit? Where is that
Let
claim?
me see the claim. Find the claim at page number 50. Prayers must not be fine.
Yes,
At page number.
yes,
When you see the first prayer,
yes,
it's a very substantive prayer. We seek a declaration of law.
yes.
That the proposed amendment, as
Hmm.
per circular dated 18th of August 2022, the first defendant to amend the constitution of the Church of India, terms of clause 12A of chapter 5 of the Constitution, whereby the retirement age of the bishop is sought to be extended from 67 to 70 as being mala fide, not of good faith, and consequently null and void.
Yes.
That declaratory really still stands in the main suit. And he asked for that was my law wanted me to point out the main prayer. My suit still survives. Then grant a permanent injunctions, restraining the defendant respondent, proceeding to amend clause 12A of chapter 5. The retirement age of the bishop from 67 to 70 years. Then we have the alternate prayer in the event the court after trial. In the interim, we saw and we had the benefit of an added order.
Where is that?
Added order. Page number C. Page number 38 starts from the operative part on 39. Page 39.
Yes.
The operative part does not have the order. After a detailed reasoning, the learned judge allows my application.
Yes.
And restrains them conducting the meeting.
Yes.
Now, and this interim order was extended. On the first day of winter vacation, kindly see page 75. A spiritual body cannot overreach the court. I mean, even a commercial body for that matter.
Now that this was forced till disposal of the suit.
Yes, yes.
Till disposal of
Yes,
your
yes,
application.
yes. Notice on, may I make this point? Can you see page 75? Can you see the date?
Yes,
That is the first day of winter vacation. And kindly see the meeting is called 21st.
yes,
Kindly see page number 76, 21st at 9 AM. Not even a day's notice. Constitution says you have to give 2 months notice to the council.
no, that is different.
Yes.
That the order of the court is in force,
Yes, it was in force.
restraining from conducting the special meeting.
Yes,
They have conducted in a meeting.
yes, the order was in force.
When that order has been passed, final order has been passed, 3rd January.
In June, not of 3rd January. I had the benefit of an order, and now they are gate crashing. They want to hold a Hooghly meeting, ratify that illegally passed resolution.
Where is that resolution?
So the resolution they are disclosing, but they have informed everybody. It's all done on hush hush, no transparency, nothing. I am on affidavit stating that they have passed the resolution. They will not give it to me.
Yes.
Therefore, let there be a stay of anything further until short notice. I will serve on the council or hear us out.
No, now that what you want to stay,
I want them to stay from acting on this illegally passed meeting.
now what is that proof that meeting has been held on
Why
that?
don't I say any resolution is passed? I'm on affidavit saying that the resolution is passed. They have not given me. Let them respond.
Office objection is kept open. Learned counsel for the appellant has submitted that. During the pendency before the trial court, he has a benefit of interim order directing the respondent number. Which respondent here?
Three.
Respondent number 3, who is the defendant in the suit, restrained from conducting a special meeting of Diocese Council on 12/9/2020 till 1 week. It has been continued.
Yes, till the dispute.
That has been continued till the disposal of the application. That is on till
3rd January.
3rd January 2023. During that winter vacation, when matter has been reserved for orders, reserved for orders on 19th December 2022, they have conducted a meeting contrary to that interim order granted by trial court and taken a decision. Further contended that in respect of violation of the interim order, he has filed a contempt.
Yes.
He has filed a contempt. Now that in view of dismissal of his application, IN number 2 by impugn order, they are proceeding.
On basis of that illegal resolution.
They have held a meeting on 19th December 2022, has passed a resolution. Now they are meeting was been held on 21st December 2022, and they have taken decision contrary to interim order passed by the trial court. In view of the above, respondents are directed not to precipitate that matter till next date of hearing.
Very good.
You will take hand summons.
Yes, please.
Issue emergent notice. In addition to that, appellant is permitted to take out hand summons to the respondents.
Very good.
Sushil Kumar for appellant. Yes, Nagraj.
Yes, you give them, yes. For reporting death of the 10th filed by the advocate for R6. Yes, R6 is dead. You are appearing for appellant. Memo is filed reporting death of respondent number 10. Learned counsel for the appellant prays 2 weeks time to ಹಾಕಿದಿರಲ್ರಿ IFR bringing LRs of deceased on records. ಅದು ಹಾಕದ್ಮೇಲೆ ಮೆಮೋ ಆಫ್ ರಿಪೋರ್ಟಿಂಗ್ ಯಾಕೆ ತೋರಿಸ್ತಾರೆ? I3 IA has filed for new earlier advocate new no objection takand mel file nodabarda. Now there is an application whether notice is ordered or not, Mr. I will for bringing LRs of deceased 10 on records, furnishing a PF issue correct notice to 7 notice agilva 10. Yes, issue notice on IA 1 of 2022. Appellant is has granted weeks time to pay the process issue notice to R7 and R9.
Number 7, Ramabhatte for appellant, Narayana Swamy PM, P. Ramaswamy Iyengar, H. Puranik.
What non-filing of the commission? Yes.
There were some students that Ram said.
Yes.
This please appoint a board committee surveyor to conduct the inquiry survey and report as per order dated 20th.
Yes.
And I have deposited as per direction. Have not exceeded the property. Thereafter, after several interest payments, somehow they have issued notice and conducted something. I moved this article on 1/9/2022. This article observed that the inspection as ordered by this court was not conducted within the period of 2 weeks. The matter will be viewed seriously. Even today, they have not very good, but the report.
No, that's no. Then government advocate should be made party. How they will have?
This is which way.
No, that is true. Report has to be submitted by the ADLR.
They should not have property action.
They don't know that procedure. Submit government advocate.
They have collected the commission.
As the government advocate. They have to communicate and get it when that he don't know when the matter will be posted. Commissioner.
They are well aware of it, but there is something behind it.
No, now that let us see whether they have conducted in a this thing.
Let
that government. Huh? ಅವರು ಈಗ ADLR ಕಂಡಕ್ಟ್ ಮಾಡಿದಾರೋ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಯಾರು ಹೇಳರಿ? No, let the government advocate pass off. Government advocate is
Number 8, A. Gopi Prakash for appellant, J. Suppareddy. ಅದ್ರ ಮೇಲೆ ಆಫೀಸ್ objection.
Not deposited by the advocate for the appellant. Appellant advocate has not deposited the.
They have deposited. Contempt proceedings was initiated. Lord, kindly see the page number 8 of my IA.
Yes.
Where the order of the contempt court.
Yes.
Where they have stated that the 5 lakhs have been deposited on 6/7.
No, what is that suit? What is the suit?
For rejection.
You are that landlord.
I am the landlord.
Yes, suit is decreed.
Suit is decreed.
What is that amount directed to be deposited?
My lords, on 10/8/21, my lords, this honorable court in the RFA proceedings has directed the appellant to deposit about 7 lakhs. That was belatedly deposited before the contempt court on 6/7/2022. Lordships will kindly see.
That amount is related to what, Mr.?
Lords,
That amount is related
this
to what?
is with respect to the arrears of the rent. They had given an undertaking
to the vacant handed over to scheduled property within 3 months from the date of order. Fail to do so, plaintiff is liberty to take an action. Further, plaintiff is liberty to conduct an inquiry on means profit in respect of illegal activity. Where is that order of this? When order is for?
10/8/2021 is the order of this honorable court, where the appellant has given an undertaking to deposit the 7 lakh rupees.
The Learned Council and the respect of the council appellant that there is an delay of 21 days pending a second application of personal.
They failed to deposit the amount.
Now, how much it is deposited?
They have deposited the 7 lakh rupees.
7 lakh
That
before
was
that.
deposited on 6/7/2022. Before the contempt proceedings in CCC number 742 of 2021. Which came to be disposed on 21st July 2022.
Yes, who is that other side?
Gopi Prakash is appearing for the appellant.
Hmm.
He has also filed a memo for withdrawal in this matter.
Who?
The appellant has filed a memo for withdrawal.
Why? Withdrawing of the appeal.
Appeal itself, because
Ah.
what has happened.
Then
my lords,
you can't withdraw that. What is there then? Memo for withdrawal is there.
But
Yeah.
one order I would like your lordship's indulgence.
Hmm.
So far as the amount which is deposited, we have filed an IA to take.
That I will permit.
Please.
I will permit both for withdrawing and permitted to withdraw that amount also.
Mean profits, we'll have to set up a
That
separate
is for
inquiry.
that this thing.
Right. Trial court, my lords. And, there are also some other areas of the rents, my lords. It's about 25 lakhs. They are still not deposited.
That you go and
Please,
execute
please,
that.
please,
Whatever that amount now deposited, take it.
we'll take it.
Some amount rent at least we will get. There is another court please to permit the appellant to withdraw the above appeal and not trust in the interest of justice. Yes. Act return at your money.
Page number 9 of the IA, my lords, where the contempt court has given a specific direction. for-
Appellant. No, that party has filed a memo. Advocate is not filed. Is it same person?
Muruliధar Hallappa is,
Muruliಧar Hallappa ಅಂತಿದೆ.
he's I'm not aware of what is transpiring between the appellant and the counsel for the appellant, my lords. But
Yes, if any other grievance, he can file an application for restore if it is not filed. Where is the signature? Appellate figure?
my IA is filed on 14/11/2022, my lords, 1 of 2022 for withdrawal. of the appeal.
The appellant himself has filed an the 7,000 rupees complaints of this under court. Such situation above appeal is not hindered on the influence in the nature of filing of appellant on the basis of handing over. Appellant himself has filed a memo on 1/8/2022 in the registry seeking leave of this court to withdraw this appeal. The respondent also filed a memo seeking permission to withdraw that first order. This court by order dated. ಯಾವತ್ತೋ ಆರ್ಡರ್ ಆಗಿದೆ ಡೆಪಾಸಿಟ್ 10/8/2021 directed the appellant to deposit 7 lakh rupees respect of rent
Arrears of the rent.
arrears of the rent. Pursuant to that, the appellant has deposited the same before this court or
Before the contempt court,
before trial court.
so contempt court, CCC number 742. The High Court only they have to post.
Then you have to seek permission in that contempt court. Will permit it to withdraw this.
Page 9 of the order of the contempt court, my lords, where it is open for the complainant to file necessary application in the pending RFA, and it is for the learned civil judge to pass orders in accordance with law for the withdrawal of the.
Yes. Has deposited 7 lakhs before this court.
Please,
The office is directed to. The respondent is permitted to withdraw that amount. Office is directed to release that amount in favor of the respondent. Only one respondent.
please, my lord.
After due verification.
I have also issued my bank statement.
Yes.
Page number 10 of the IA.
No, that they will after due verification. They will
Please,
verify and.
Please.
Innೊಂದು. Varnan, what is that date of your memo for withdrawing?
My application for withdrawal is on 14/11/2022.
Who
IA
has
1
filed this for transferring that amount? You have filed,
for withdrawal of the amount.
when you have filed
14/11/2022.
14/11/2022, appellant on 7th below mentioned account. Respondent seeks to transfer that amount deposited by the appellant.
Please, my lords.
Yes, transfer to where?
The bank details have been furnished in the application itself.
Yes, permitted to withdraw. Has filed a memo on 14/11/2022.
IA,
It is IA.
please, IA
Yes.
1 of 2022.
Filed an IA 1 of 2021.
22.
22, and that you have passed on. Amele, the appellant himself has filed a memo in the registry dated 1/8/2022, taking leave of this court to withdraw the above appeal as not pressed. The memo is taken on record. The appeal is dismissed as not pressed. All pending applications are disposed of.
Number 9, Chokka writing for appellant.
They are receiving the same address, but the postal tag
What is the suit, Mr.?
suit for partition, some has filed the suit for partition against the father. It itself is not reasonable, that the suit property acquired by the
No, there is no any interim order not to draw final degree proceeding.
taking this advantage. They are receiving the same address, but
Now, what is the stage in that FDP?
The report service copy have taken that.
Now that who are you?
But I am at the father,
No, is there any share allotted to you also?
that the son has filed the suit against the father.
What has happened to that suit?
That the suit properties are acquired by the Ch-12 tribe of the father of the apparent blood. Father of the apparent blood had 12 persons. He has made as a only one person has filed the suit.
Learned counsel for appellant has submitted that. He has taken a notice to that respondent. It is written with no such addressee. During that pendency, they have filed a final degree proceedings, and that commissioner has been appointed. The circumstances. The trial court is the drawing of final degree proceedings. He stayed. Week's time is granted to file a correct address, furnish correct address, and PF to issue notice to respondent. In addition to that, appellant is permitted to serve appeal memo on counsel appearing for the respondent before the trial.
For appellant. Serial number 10.
Each time is granted to comply the top subject. But all respondents will take notice. Yes, sole respondent. You are representing Uma Devi. Yes. Yes. Gautam AR. That counsel is undertaken to appear for respondent number 1. What you say about the delay, Mr. In that appeal? There are no objections. Yes. And office is directed to show his name for respondent number 1. There is a delay of 359 days in filing an appeal. IA 1 of 2021 is filed for condonation of delay. Respondent has no objection to condone the delay for the reasons stated in the accompanying affidavit. Delay of 359 days in filing an appeal is condoned. IA 1 of 2021 is allowed. What has that in your case he has to take notice. Nagraj RC. No, now that delay in that case will be pending. Let him say if he has no objection in your case to condone delay, then his case will be condoned. Because tomorrow he may object for your case. That delay is also there in your case. Oh, you have no objection for condoning his delay. Yes, it's fair. See, Nagaraj RC is directed to take notice. Yes, Mr. You are appearing. RC is directed to take notice for respondents in RFA trouble. Karnataka Council for the appellant in RFA CRAB is directed to serve one set of copies on Nagaraj RC. Now, what is that? This thing. What has happened to the? Who are you?
I'm the plaintiff.
You are the plaintiff.
I'm the plaintiff.
What has happened? What has happened to your suit?
It is partially defeated. My only defense is there has been a emotional partition, but not partition in accordance with that. I'm entitled to equal share.
You are a daughter. You are entitled to equal share.
1/12 has been awarded. I'm paying for equal share.
How many members are there in that family?
Yes, that is also one more ground of that all of them parties were not, all the necessary parties were not made parties. So is one of their grounds. I shall not. I will comment only when.
No, now that it is your suit, you are not filing any application for FDP. Now that position is with them. Parties are directed not to create third-party interest in respect of group scheduled property till next date of. Yes.
Number 12, for appellant.
I have complained the office of 3/6/2022
We did it, sir. Still 5 more objections are there, Mr. Actual number of the delay, agreed para and the appeal memorandum has to be taken.
I will comply. Meanwhile, on submission, it is a case for my case is Belti. There is no opportunity was given to cross-examine the PW1. With that direction, it is demanded.
No, without issuing the notice to other side, it cannot be remanded. Just they have a benefit of order.
Yes.
Yes, week's time is granted to comply that.
Number 13, PM for appellant.
Yes, week's time is granted to comply the compensation.
14, Joseph Watson Samuel for appellant. Abhinava Ramanand.
Week's time is granted to comply the compensation.
Number 50, Raghavendra A. Kulkarni for appellant. Girish S. Hegde.
Yes, 2 weeks.
Serial number 16, D.K. Manjunath for appellant.
Time is granted.
Number 17, V.R. Balaraj for appellant.
Now, what is that order you have challenged? FDP. Petition filed. Third share. Yes.
That's what I decree.
Yes.
Against me, that before this, number 1657. That is this. Why did you make it? That is 1657. We have these things. Thereafter, you have to check the FTP. During the pregnancy, the FTP proceedings, suspend the original petition right. During the execution of the FTP proceedings, they have a being in favor of
Yes, we'll have it at 2:30. We'll verify. Judgment on that one. Or 2:30 drag 1:30. Yes.
Number 18, Sanjay for appellant.
What is the order you are challenging? Then you have to file an MFA under section 54 of Land Acquisition Act, not RFA. Karnataka Housing Board has made a reference 77(1) of right to fair compensation. No, it is under 77(1). There is a provision for this thing. What is that? Land acquisition. Which is that provision for in the Old Act? It is section 54.
New Act is
77 for reference. Other mailgade.
96 is for appeal.
Then you have to file in a 90 under 96.
96 have done, but here what has happened?
Miscellaneous appeal has to be filed.
Here what has happened? You have gone on the issue of title.
No, I'm not on that point. If that order is passed,
You have determined the title.
it is all the ground for you to rise. This is not under that CPC. Order is passed under 77(1) of Land Acquisition Act. There is a provision for filing an appeal, which is that 90?
6.
Exemption. No, 96 is not there.
You have raised the objection saying that there's to be filed under
96 of
CPC.
96 CPC ಬರಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. There is a provision for appeal to that High Court 74, Mr. You see that requiring body or any person aggrieved by an award passed by the authority under 69 may file an appeal to that High Court within 60 days. 69. Provided the High Court may, if it is satisfied that appellant was present a sufficient cause to filing every appeal. Yes, Mr.
Whether the High Court recognizes legal perspective. That is, perspective again decrease in original issue. Miscellaneous perspective, that is perspective in any other judgment.
That is what that, Mr. You have to file any MFA under 74 or any other provision you have to search out in that Land Acquisition Act. 74, they said appeal. Required body or any person aggrieved by that award passed by that authority under 69. What is that 69? Determination award by the authority. You have filed a reference under 77. Huh? Payment of compensation.
37.
Karnataka Housing Board had made a reference under 77(1) of the right. 77(1) payment of compensation on making an award under 30, collector shall tender in a payment of the compensation awarded when 20 deposit in account. Person entitled compensation not consent received if it is so and so. Probate if the collector shall deposit that amount compensation order with reference under 64. Yes, it is under 64. Is submitted provided person admitted interest in received so and so. Person shall be received amount so and so. Yes, 64. Reference to the capacity. Any person interested who has not accepted the award within 30 days, the application will be spread that ground on which the objection amount so and so. Letter statement of authority. Restrictions scope. Public. See, you have to file an appeal under that Land Acquisition Act. You have to verify, but here required body or any person aggrieved by that award passed by the authority under 69 may file an appeal to that shall be heard as an exclusive possible endeavor shall be made disposed of such an appeal within 6 months from the date of appeal presented to the High Court.
What has happened is in this case, petition filed by the reference court, High Court. So, under section 30 of land, payment of compensation determined by
That is, there were 12 claimants, including claimant number 1.
Yes.
So, ಇಲ್ಲಿ the reference court ಅಲ್ಲಿ what they did, they determined the title stating that
No, Mr. It is not on that merit. You are not assisting the court. This is under Land Acquisition Act. Then appeal under section 96 CPC, it is not maintainable because it is only on the degree. Now that what is that provision under that Land Acquisition Act, you are not ready to point out. I myself have to search authority. Determination by that authority, collector may interest excess. Foreign body, any person agreed with the award passed by the authority under 69 file and appeal to the High Court within 6 days from the award, provided the High Court may be satisfied that appellant was apart from filing an appeal within such time. Every appeal recording shall be heard as the High Court means High Court within the jurisdiction of the land proposed.
section 7.
77, but they have said that High Court. Who is that? Anybody is there under land acquisition?
27.
Yes, any advocates is there who are dealing with that land acquisition matters. Yes, we'll have it on Monday. I will verify, Mr. I myself will verify. You are not ready.
Yes, again, connected matter.
Non-serving of an hand summons to R1. No, that is different. Trial court serving a copy to the trial court is not in a service. He may say accept, he may not be say no. But that is not in a service. If it is accept and file an wakalat, it's well and good. Or he, no, that whether he is permanently residing abroad or he is on tour. That is what that has to be inquired and file an affidavit. You have to inquire from somebody else. If it is permanently in the abroad, then you have to take any notice by this thing. If he is coming back, then you can serve it. Yes. Learned counsel for not trial court advocate. If he is coming back, you have to serve him. Learned counsel for what is their trial court case pending idea? What is this matter? MFA ಕೊಡ್ರಿ. Learned counsel for ಎಲ್ಲಿದೆ ಆರ್ಡರ್? This court order. Then the court has directed to file an affidavit, Mr.
Last week.
14/7/22.
14/7/22,
sir.
Counsel for appellant Grace. Learned counsel for the petitioner. ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗ್ಬೇಕ್ರಿ? Yes, learned counsel for the petitioner. Grace. Each time to file a better affidavit. Meantime, we seek permission of this court to survey copy on the counsel appearing for respondent before the trial court. The petitioner is permitted to serve a copy of the petition copy and appeal memo copy on the counsel appearing for the respondent before the trial court. It also permitted. Recalling that order 28/2022. What is that order, Mr.?
They are after that, 14/2020. After that, I filed two applications.
Matter listed today, it is submitted the application from the commissioner of his right. Accordingly, application was filed for condemnation of the office is raised the objection. Nowhere in 2 years. Council has not made any effort to rectify the office objection. Office stand abated. Yes, appeal is abated. I filed an application for where is that? Serial number is eh? Yes, learned counsel for the appellant has filed IA for setting aside that abatement and bringing a loss of deceased appellant. Office to verify put up the same. Next week. We'll allow that application, then we need not be for recalling. Court said that it is abate. Now we are filing an application for abatement, setting aside that abatement. Non-prosecution model. They said, since you have not taken a steps, it is abated. Court said. You order nodadilla. Yen madirtare court nora. Now it is available in that website. Recalling that order. What is that order? Despite granting a time, appellant are not instructed the counsel on record to complete the office objection. You have not completed that office objection. Yes. Pending. Yes, pending consideration of IA1 of 2022. 2 weeks time is granted to complete that office objection. First comply, then we'll. Yes. Notice. Oh, now that you have to file an application for paper publication. That is the procedure. No, that is what that. Now you have to file application for paper publication. And other respondent is not there, then paper has to be taken. No, not against whom. You have to take in a publication. Itara case hakidivi anta. That is the procedure. You verify and do it. Yes. I file an application, then I will permit it. Yes.
Lord, I beg to appear for the respondents' counsel.
Yes, Mr. What is
But it has already been admitted.
Yes.
Every order has been granted. No, every order is not granted. My need to continue not.
Lord, it's not really an interim order. My Lord, what had happened was that when they were on caveat, and therefore a request was made for objections, and we said till the next date we will not press the order. Order of injunction has been granted. It is not really a stay, my Lord, that was granted.
Yes. Now, what is the stage of the suit now? Issues. Yes. No, otherwise this arrangement can be continued and directed them to dispose of as early as possible.
Lord, the difficulty is,
And
I have the benefit of an interim order, but my Lord, before the trial court, by virtue of a considered order,
and they are now continuing to use the mark. I have a registered mark. They don't even have a registered mark. Despite that, my lord, now if I am not permitted to use and they are permitted to use, my lord, the whole purpose of registration of a trademark could be defeated.
No, that you have not been restrained to use. You can also use.
No,
but
quite right,
you-
my lord. But the difficulty is, they are, my lord, using it. They don't have a registered mark. In fact, if a lordship's notice, what had happened was in this case, the suit is filed.
No. I'm not hearing that matter on that. I say that if both as considered, then it can be instead of that. Now that this order was there.
My lord, then can I just request your lordship may keep it any day next week? I'll just take instructions, my lord, if that is.
Instruction and I direct that. That is that better. Yes.
I'll just take instructions, my lord, any short.
Yes. But the request for use this matter next week. Interim order, yes, interim order granted earlier is extended till next day. Interim arrangement, same.
Interim
Yes.
arrangement.
Yes, interim arrangement. But anyway,
Great. So great.
Yes, interim arrangement made earlier. Order by order of this court will continue till next date of hearing. Which date you want, Mr. Yes, when do you want? Nand Kumar is, yes, Mr. Senior Counsel. He is busy in other court, I think. No, if it is convenient for, otherwise it will come next week. Yes, next week. Who?
Instructing counsel.
25th. Yes, on that day, you have to say that otherwise matter has to go on with that merit.
Number 24, data is argument of our opponent.
24. CA continuation of delay for additional for stay, then notice has to go. There is a delay. Huh? But there is a delay. How can you grant interim order? Yes, pass out.
Number 25.
Yes. Other says, what has happened to that notice?
I was directed to pay this within 1 day. I have done also.
Huh?
ಸರ್ವಾಗಿದೆ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದೆ
ಆಗಿದೆಯಾ? Who has filed? ಇಲ್ಲ, somebody has filed and ವಕಾಲತ್ ಇರಿಸಿ ನಾನು.
ಓಪಣ್ಣ PC.
Yes.
SK ವೆಂಕಟ ರೆಡ್ಡಿ.
They are not from that.
ಎಲ್ಲ ರೆಪ್ರೆಸೆಂಟ್.
Yes. Respondent has appeared through that council office to note their name. Yes.
Number 26, Kamalappa PM for appellant.
Point of time is great, for business, great. And they applied for an RFA in 1913.
Yes.
Where in that particular given located as in RFA, the appeal was remanded back.
Hmm.
And after remanding the matter, and before this, of the party detail of this. Except the from paying the court fee, and this all put in the pays other than not like fair. Taking the appellant as an indigent.
Very good.
But in the delay also the same has been expected. The arising out of the same judgment, the fee was bad.
It is around order of the Prime Court is decided. Prime Court is directed to request the court and No, why that appeal?
Earlier, I filed previous.
No, that your application is dismissed for it.
Earlier point of time, I filed previous. Previous was dismissed on the ground that the appellant was possessing some property. So against that order, I preferred MFA.
This court had said that you may be treated as an indigent in that case.
That case, and that was converted as.
No, against that, now you have filed an appeal. Now that what is that this thing? Which is the serial number?
Number 1.
Serial number is
Sir, 26.
26. Now that again that inquiry is required. No. The other court has to get in a report from that local authority whether you are having in a property or not.
All the properties are the subject matter of the property. That is what the MFA has been said. The operating.
No. I am asking that what is the law? See, you have been treated as an indigent person in that suit. Whether that benefit will be continued in this appeal or here again, which is that?
In the same judgment.
Yeah, what has happened that?
Against the same judgment, the suit was dismissed. And OS 895/2005. At that point of time, it was an immediate person. But however, the appeal was remanded back to the trial.
The same appeal, this is second time.
Same.
This is second round.
Yes.
Where is that order for treating an indigent person? Where is that order? What?
Page number.
I was stated in your application.
Page number 48, please.
Page number?
48, the degree.
Yes.
Originally suit claim.
Hmm.
Originally the plaintiff filed this on part with the and
Yes. Declaration that the plaintiff.
Final disclosure.
Now, where is that in the RFA? You have been treated as an indigent person.
RFA again is very safe. I was thinking as an indigent person.
Adi kelli, where is that material? First, there should be an order, is it not? As like IA, is not that same thing will be applicable here also. That you have,
Here I have been treated as
let me know that after that, before this court, one time you have been treated indigent person. Then I can pass similar order. That copy should be there for me to reference, is it not? You produce that copy, when you will produce. Yes, you should have, party should have having that copy. And is there any reference in that remand judgment that you have been treated as an indigent person? Anywhere in the judgment, it is there. Then we don't know whether you have paid the court fee or you have been treated as an indigent person.
But can I read?
Verify.
Post matter, at the 1676 or 13 2013, 19 judgment, 19.
Yes. No, you apply and verify. Adu upload agiralva avala.
That will be part of the order.
Alla order alla upload madiralva. No, that which is that RFM?
RFA 1676 of 13.
Office is directed to put up the records in respect of RFA 1676, which was disposed of on so and so date.
2011 to 2019.
Yes. In the meantime, if you find, you also produce.
Yes, Balagananda for appellate, Adi for appeal, Kevin Narasimhan.
Appellate, matter is admitted, I have filed my paper. And status quo order is granted. So they sought for a modification of the status quo order. My lord, Matt was a very short point question. The suit property is acquired by the PDA, therefore suit is not maintainable. That is the tenor of the judgment of the trial court. But the trial court completely ignored itself and misdirected without considering the commissioner reported commissioner's evidence. And I have got a good case to convince your lordship.
No, you are that owner.
No.
You are the plaintiff.
I purchase. Now my submission is
No, you are the plaintiff.
Yes.
You are sued for
Injunction is rejected.
rejected.
But throughout the suit, my lord had the benefit of status quo order. This honorable court granted it. Now my actual submission is. My lord, matter may kindly be heard on merits itself.
No, that cannot be. In all matters, RFA, it is not like writ petition. Mr.
Sorry, ma'am.
Everybody in all cases say that only single matter points it can be. It cannot be.
Open matter ಜಾಸ್ತಿ ಅಂತ.
I have to see that evidence and all. It is an appeal. Now that status quo order is a reasonable interim order. If you are in the position, you continue. That's all.
This council has filed IA for vacating the interim order.
Yes.
Now we collect all the records and proceedings of matter.
Yes. Admit ಆಗಿದೆಯಾ?
Yes.
Yes. At the request of the parties, this matter of 2 weeks. Let us see.
Matter serial number 28, Sanat Kumar Shetty case for appellant, Prabhupada Bhikindi.
What 2015 matter? Now that we'll see what is that matter. Yes. What is that direction? Now, what is that you are filing? No, objection to what IA you are filing? 2015. May I say again, sir, where is that provision for filing an objection to the payment? Only IA you can file it, Mr. Now that we have to see that on records and findings and the evidence, we have to decide. Yes. Yes.
That order in the appeal is an order. The trial court
No, that you are a defendant.
and the dependent.
Defendant appeal.
Order in lieu is an order
Suit for
for attachment before death. Suit for recovery of amount. Plaintiffs are, the defendants are the legal representatives of one M. Ramchandra.
yes. No,
Plaintiff contends the law.
no, what is that order you are challenging? IA filed by the
Yes, ma'am.
plaintiff hereby allowed. Him IA is allowed.
They are IAS alone and the defendant.
Or defendant appeal.
Yes. Attachment before judgment has been passed. Lord, it is suit for recovery of amount.
No, Mr. See, let there be a status quo directed to dispose of the suit as early as possible. Attachment can be set aside.
Attachment before judgment. It's a serious order.
That's what.
Unless the.
See,
No, that is not.
no, Mr. Wait. Now that there is an interim order saying that
No interim order.
no interim order. What has happened to that attachment?
Yeah, that is pending.
What has happened to that order is not implemented? Wait. I will permit you to, Mr. We both see.
Yes. It's an attachment before judgment. Once the judgment is passed, it becomes absolute. Then it will be put into sale, the execution. Lord, that order could not have been passed. The property could not have been attached at all.
No, that what is that prejudicial cost to you?
Lord, it's a serious matter, Lord. Unless the court is satisfied
No, that is true.
Yes,
Now
sir.
that
It is absolutely no satisfaction. Good.
all 5 years,
Yes,
this
sir.
was there. Now I will
Lord,
direct that the
it's
suit.
not like an injunction order.
But
Here,
we have-
because the suit is filed, I cannot refrain from dealing with my problem.
You have suffered this for last 5 years.
Lord,
Now that it is for an admission, if I admit it, again it will be there for another 3 years.
it may be disposed of by.
Okay, it is for an admission. Appeal has to be admitted, paper book has to be filed, then it
ಇಲ್ಲ,
is
MFA.
MFA, then it has to be posted for hearing. Therefore, I said, direct the trial court to dispose of that. If you make out any case now, then I will admit this.
Yes, sir. I will try to.
Yes. Then because there is no interim order for last 5 years.
I will try to convince you.
No, that I can see that I will admit it. Yes.
Yes,
Or
sir.
admit.
Taking advantage of this. Trial court.
No. Who said that in all appeals we have to be admitted? That doesn't mean that it will stop from the trial court to proceed further.
What do you think that let them be part on that?
Heard, admit. The trial court may proceed with the suit in accordance.
There is no stay of the. Proceed with the matter.
Our satisfaction is now that some of the courts is also like that, not to draw that final degree proceedings ಅಂತ ಅಂದ್ರೆ ಅವರು FDP ಶುರುನೇ ಮಾಡೋದಿಲ್ಲ. That is the problem. By the time he has some safety saying that my appeal is pending. Now you get it that appeal itself is disposed of, then it will become infraction. Both are having some security in their clients.
Number 29 adjourned, serial number 30, Indra Raman for appellant, Adesh Kumar.
For the trial court, the prayer sought was to retain the respondent as responding villa, disposing.
No, now that you are in a plaintiff. No, plaintiff.
Yeah, I know that indeed.
Yes. Plaintiff's appeal. A suit for recovery of money. Then what is that application you have filed?
The application under order 39
Yes.
seeking an order explaining the respondent from alienating the suit schedule.
What is that this thing?
The respondent in the.
Where is that order?
Which I am. Page 11.
Yes. Why that your application is dismissed? You read that internal page 21, in page 31. I've carefully gone through that above case.
My plot the submission is that my appeal is now infructuous.
Yes.
My appeal is now infructuous because the apartments that I sought to be restrained from being disposed have already been disposed of. To that end, my appeal is infructuous. My only request is that may be disposed of as infructuous.
What that you are saying?
With the direction, my lord, that it be disposed, the suit be
Appeal.
disposed of expeditious.
Yes. Yes. Learned counsel for you file a memo to that. Do that memo. Yes. Learned counsel for. Yes, now they will give us. Learned counsel for the appellant has filed a memo stating that the seeking leave of this court to withdraw this appeal, having become infructuous. The memo is taken on record. The appeal is dismissed, having become infructuous. Since suit of the year 2016 is pending, the trial court is directed to dispose of the suit as expeditiously as possible. The parties are directed
The request to be in 6 months. my lord.
as expeditiously as possible, not later than 10 months. The date of register of the copies. Parties are directed to cooperate for early disposal of the suit. Yes.
Basavaraju for appellant, Prasad Hegde, Jayant Punjari.
Yes.
My lord, serial number 31, my lord. I appeal for the appellant. Matter is likely to be settled, my lord. We have given them a proposal on the last date.
What is that? No, they are ready. Their parties are present for settlement, Mr. Where are you then?
My lord, our parties are not there. They said they have not given us instructions. Kindly pray for a week time, my lord. They said they are going to talk with the family members.
No, that first you finalize and ask the parties to come. Otherwise, unnecessary they are coming. Yes. Yes. When do you want, Mr.?
Please, my lord, next week, my lord. Date may be given, my lord.
Do this matter on next Thursday.
Grateful, my lord.
Number 32, MS Nagaraja for appellant. Sunday. 100 matters.
Yes, madam. What is this? No, suit for? Yes. Yes. The last occasion he has made some submission. What is it? What is that? Where is it? Where is your friend? Pass off. You just call him and inform. If he, for that reason only, it is the thing. This, if he is not appearing, means he has no instruction. Let us say pass over. If you say that, I can. Otherwise, I have to dismiss for default. In his absence, we cannot pass an order on merit. 2:30. You just call him and inform. If he agreed, then I will pass an order. Yes. No, that now you are in that government. No, one matter. ಇದು commissioner appointment. ಹೇಳಿದ್ರಾ? Then your colleague has been informed. Yes.
Number 33, Tanvir Pasha is for appellant. Shanti Bhushan ASJ.
Yes, Tanvir Pasha. So,
Number 34, Gita Devi MP for appellant.
yes, madam. What is it? Why your petition is dismissed? No, there. Yes. Again, it is remanded to give an opportunity and pass an order. Yes. And again, you have to send it back to the PSI court on the. Where is that judgment? They have served unrepresented. 2:30. You get it, you will dispose of it. Because nobody is representing.
Number 35, S.V. Prakash for appellant. Siddharth B.
Lord, I appeal. Lord, this is a plaintiff's appeal, my lord. Against my lord, vacation of interim ex parte interim order granted. My lord, the appellant is the plaintiff, and he instituted the suit, my lord, for decree of permanent injunction against, my lord, the defendants.
Yes.
My lord, it is a house site measuring 30 feet by 40 feet.
Yes.
My lord, I claimed the right under a gifted executed by my brother, my lord, one Mr.
Yes.
Suresh.
Yes.
And my lord, the trial court, the other side, my lord, the defendants, according to me, have no semblance of right over this.
My lord, they, my lord, tried to say that they are in possession.
Yeah.
And my prayer is that not to interfere with my possession and not to put up any construction.
Yes.
My lord, it is a suit for bare injunction. Your
Now,
trial court.
when ex parte order has been passed,
My lord, ex parte, my lord, on the date of filing the suit itself, my lord.
what is that ex parte order?
Order is, my lord, rejection, my lord, restraining them from interfering with my possession and not to put up construction. That is the,
What is the date, Mr. Prakash?
my lord, date, my lord.
1/10/2018.
One?
1/10/2018.
18.
My lord,
Was
this
disclosed after January.
impugned order is passed on 9th January 2019.
Now that it is for a bare injunction suit, both the parties maintain status quo directed to dispose of.
There's a suit filed by me, where the interim injunction has been granted by the court. And after not vacated their interim order.
Then no interim order passed against whom?
Against the very appellant.
That is operating.
Operating.
That he has not challenged.
It's not.
Yes, Mr. Prakash. Then how can that?
No, my lord, that is not correct. Anyway, my lord, may I submit this? My lord? May I submit this? My lord, impugned order is dated 9th January 2019. My lord, we are in, my lord, 2023.
Yes.
My lord, suit is now matured for, my lord, evidence. My lord, your lordship may direct the court to, my lord, to decide the suit. My lord, within, my lord, a specified time. And my
Yes.
lord, let trial court decide the suit on the basis of the materials that would be produced by the court without being influenced by the observation made.
Observation in this. Yes, 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 that we can do it. Yes. Right. This appeal is filed by
Plaintiff.
Under Order 43, Rule 1 R of the CPC, challenging order dated 9th January 2019, passed by 35th Additional City Civil and Session Judge, Bangalore, on IA number 1 and 2, whereby IA number 1 is dismissed and IA number 2 filed by the defendant is allowed. Plaintiff has filed a suit for permanent injunction against the defendant in OS number 7233 of 2018 before Additional City Civil and Session Judge, Bangalore, in OS number 7233 of 2018. Along with the suit, he has filed an IA number 1 under Order 39, Rule 1 and 2, seeking injunction, temporary injunction restraining the defendant from carrying on construction work over the suit scheduled property. He has obtained ex parte interim order on 1/10/2018.
310, Lord. 310.
3/10/2018. On service of summons, the respondent defendant appeared through this counsel, have filed a written statement, and they have filed an IA number 2 under Order 39, Rule 4 of the CPC for vacating that interim order, ex parte interim order granted by the trial court. After hearing that parties, the impugned order is passed. IA 1 filed by the plaintiff is rejected. IA 2 is allowed. The interim ex parte interim order granted on 3/10/2018 is vacated by impugned order dated 9th January 2019. Being agreed by the same, the plaintiff appellant is before this court. Now, the suit is set down for evidence.
The evidence
Evidence. Yeah, evidence. The suit is only for the bare injunction. Under these circumstances, only relief can be granted in this appeal is the trial court is directed to dispose of the suit itself on merit, not later than 6 months from date of registry of a copy of this order. Accordingly, the appeal is disposed of. The trial court is directed to dispose of the suit not later than 6 months from date of receipt of the copy of this order. The parties are directed to cooperate for early disposal of the suit. It is made clear that the trial court has to pass an order. A trial court has to decide the suit on merit without influencing any observation made in impugn order.
Obliged, madam.
Yes. All pending applications are disposed.
Maheshaya for appellate, Abhinay Whitey.
Yes, Mr. Hiremath. Yes, Mr. Abhinay. What stage it is dismissed for non-prosecution? Huh? Evidence stage. Why you are not represented through counsel? IA being in a Procedural 21 appellant, evidence is not completed on murder state even 7 long years. 7 long years, Mr. Then you have to give up for interest. That is, yes. If you succeed.
Yeah.
This appeal is filed by applicant. Section 23(1) of Railways Crime Tribunal Act 1987. Challenging order. Is that date of order? 7th November 2018, whereby application filed by the applicant for restoration of or past restoration for dismissal of the application for non-prosecution by order dated 24/8/2018. The applicant has filed an application before Railway Claims Tribunal seeking a compensation. Is it a case of death or injury? Or a compensation for death of, what is his name? Nagaraj Avra idare. Huh? What is his name? For death of death of the Guranna Devkar father. Yes. Death of one Guranna Devkar, father of the applicant. Since when the matter is set down for the evidence, there is no cooperation from the applicant. The appeal is dismissed for non-prosecution on 24/8/2018. Thereafter, the appellant has filed an application for restoration. Same has been dismissed by impugn order, being agreed by the same. The applicant is before this court. So and so learned counsel appearing for the applicant has submitted that the applicants are illiterate villagers. They are not aware of the procedure before the claim tribunal. Their counsel is also not received any proper instruction from their parties. Therefore, they are not in position to proceed in that. They was not in the position. They have not assisted the court disposing of that appeal. Since the applicant has lost his father in a railway accident, they are entitled for the compensation. If this court grant one more opportunity, the applicant will cooperate for disposal of the appeal without taking any further adjournment. And he also submitted that for the delay period is concerned, he will not claim for any interest. See, now, learned counsel appearing for the respondent has submitted that the tribunal has given a number of opportunity to that applicant to establish their case, even for 7 more years, even more than 7 years. The case was pending for evidence of the applicant. They have not produced any evidence. Since they are not interested in prosecuting the case, the tribunal has dismissed that. He further contended that if this court restored that appeal and permitted the applicant to prosecute the case, delay caused due to that failure on the part of the applicant, even applicant, if it is succeeded in that appeal before the tribunal, they are not entitled for the interest for the delayed period of 7 years. Or the learned counsel for the parties. The application filed by the applicant before the claim tribunal has been dismissed for default. The ground that the applicant has not adduced any evidence. The tribunal has granted a sufficient time. The appeal was pending more than 7 years before the tribunal. The tribunal has rightly dismissed that appeal. However, in the interest of justice, since the railway, since the Railways Act is a beneficial legislation for the benefit of the victim or the LRs of that deceased to get compensation, and in the interest of justice, the appeal is allowed. The application filed by the applicant for restoration of dismissal order dated 24/8/2018 is also allowed. The claim petition 193 of 2017 pending before the claim tribunal is restored, subject to condition. If applicant is succeeded in this appeal, he is not entitled for interest for a period of 7 years. It is also made clear that applicant has to cooperate for early disposal of the appeal.
10 years, this was not right. 10 years.
Huh?
11 years ago.
It is pending before this court. Therefore, I have seen that. Maybe because of pendency also. That at least 7 years.
Serial number 37. Shilpa Shah for opponent.
Yes. Now that you verify all that cases which is yesterday one matter I have disposed of by following the Supreme Court judgment, send it back that. We can dispose of all these matters also after service, verify whenever that service is completed, move before the court instead of pending here. Or admit. Say as by for.
38. Ajay AN for appellant.
Yes, Mr. Raj.
Probate to the bill.
Yes.
The deceased member has completed all her assets to Ramakrishna and Mysore
Yeah.
and one other person. What happens is that the witness comes and gives evidence. And then he says that she has signed in front of all of us have signed in, one more witness has signed. All of us have signed in. ಕನ್ನಡದಲ್ಲಿ ಒಂಥರ ಯೋಚನೆ ಮಾಡ್ತಾರೆ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಬರೆಯುವಾಗ ಪ್ಯಾರಾಗ್ರಾಫ್ ವ್ಯತ್ಯಾಸ ಆಗುತ್ತೆ. So what has happened because of that is that records just take the page number 22 minutes, page number 22, paragraph 11. Sorry. Paper book, it is,
You are referring to that appeal memo or paper book?
no, sir, I think not the paper.
Yeah.
The order starts at page 70.
17.
No, sir, 57. Relevant page 57.
Yes.
Says, let's read the entire order and then I'll explain.
Yes.
The point number 8. Petitioner has filed his petition seeking probate of the will in respect to bill dated 20th of January 2020 executed by deceased Marshal. As per section 76 of the Act of Probate, the petition has whether the document put forward as the last will and testament of the deceased person fully executed and attested in accordance with law, and at the time of the execution of the will, the state had subsequent. The petitioner has examined endless location attesting witness to the will as PW. I have gone through the evidence of PW. Essential conditions for the valid attestation as per section 3 of the Transport Property Act are who are no witnesses who have seen the executor sign the instrument or have received from him a personal acknowledgement of the signature. Two, with a group of attest on their witness to this fact that each of them will sign the instrument because of the executor. It's essential that the witness should have their signature and more understanding. That is, for the purpose of attesting that they have seen the executed sign or have received from him a personal acknowledgement of the signature on the will. According to clause C of section 3 of the Act, the will should be attested by two or more witnesses, each of whom have seen the testator sign or affix their mark to the will. Apart from this, the attesting witness should also sign the will in presence of the testator. The component of the will has to prove by examining the one attesting witness that the attesting witness saw the testator sign the will and himself a sign. Yet, concern of the will, mandates the attesting witness can sign the will in the presence of the testator. This particularly to be clear, in this location, already in his examination, Marshal has signed on each detail of the will in his presence. There is absolutely no whisper in his affidavit about he having signed the will in presence of the testator, namely Marshal. There is absolutely no whisper in the evidence of he has signed the will in presence of the testator. In order to get this court, the attestation must be fully proved and confirming the evidence of the attesting witness that not only the testator has put the signature or come impression to the attesting witness, but the attesting witness has also signed the will in presence.
So what is that evidence of the attesting?
I will show you. Page number 10.
Yes.
Paragraph 2, I stated that I am a permanent resident of the address in Chico and senior accountant at now.
Yes.
I stated about that I know she she was my family. I stated about that she was a devotee of Ram and she had expressed her intention to execute all the people and remove the sins of charity after a day. She was a spinster, no family members to celebrate. That's then the will. I stated about that I was present on 21/2020 when Srimati asked to I have the estate of the will. I have signed the will as
No, that will has not been challenged by any family members.
There's no family member. Three sisters. Three sisters are there. These are the two things we were there. They were retired school teachers. They were only devoted to Ramakrishna.
Now, who is that petitioner?
Petitioner is named as the executive. Petitioner, Your Honor, is petitioner.
No, it is not in favor of that ashram.
No, my lord, he's working in the ashram as an engineer.
No, that's right. No, ultimately, it is for the ashram.
One part is for the ashram. There are two trusts.
No,
So.
anyhow, that is Umashankar is representing the trust, not for his personal. Now that, what is the procedure? Whether you are here, you have to take a paper notification since there is in this bill.
In the period season,
No, that's what I am asking. I've seen 2 or 3 matters today. What is the procedure here? Because there is no respondent. Is it the procedure?
Petition is filed.
No. For the appeal is concerned, whether here you have to take in a paper publication because that order is there, not in your favor. Is it?
I have taken paper publication.
No, that is true before that P&S case court. No, what about here? You just verify that procedure. Yes. No, that's the if it is filed before the High Court also. No, original side there is no difficulties. What about this in appeal stage?
There is no requirement because the appeal stage cannot be seen on the 2 days before that. What has happened? This is let the records. I want to see the original because I had produced.
No, that's the
But
hearing that matter is whether it requires for any paper publication.
The NCR was called for NCR because to see whether the paper publication is there or not, they called for the NCR.
Yes. No, are you sure that this is the procedure? Yes, then you will post for hearing and hear that matter. If there is no. No, the procedure is that it has to be admitted, then it has to be heard.
There is no respondent. Ultimately, charitable trust. Charitable trust has to put money out of its pocket for the person. It's a matter of state. I'll just show Your Honor the bill. Page number 15.
Now that whether this court can grant or it has to go back to that first appellate court.
I see what my lord. Because right or wrong, they have interpreted one particular. Why get into all? The Lord may just remand the matter back to the same court, giving me an opportunity to bring my witness and identify the signature.
One more opportunity has to be given. Yes, Pastor. Afternoon, Navil. Yes. After finishing, I have some other matters after 2:30. Afternoon. Yes. Yes.
Manoj, I appear for the appellant in this matter, Manoj, serial number 39. Manoj, I seek for a short accommodation in this matter. An interim order was granted last date, subject to the condition that we deposit somehow rupees 1,50,000 within a week, which we have complied with.
Yes. Yes, he wants time, madam, next week. Yes, at the request of counsel for the appellant. Use this matter next week.
Number 40, number 41, Ahmad SN for appellate.
Yes. You are a defendant. Defendant 7 appeal. Suit for partition. What is that order you are challenging? Yeah, filed and the plaintiff is blah, blah, blah. Yes, that is the reasonable order.
The father and all the children.
That seven, all are family members. Yes.
That was executed because of Bangalore. And the nation has been changed to his name. And there was understanding that in the
No, 1985, what they have executed? GPA. GPA and the sever of seventh defendant. GPA for what? Is it a GPA with consideration? Then what is your right for properties to be alienated? Oh, that is what court said. If you are not alienating, don't alienate till the disposal. They are disputing that executing the GPA and all. Now court has to decide.
All the
That is the threat. See, that is the threat. All documents in your favor, you may alienate and create third party interest. Again, that they have to implement and third party. Therefore, no, that,
and the second criteria that purchase property.
No,
Portion
that-
of property.
there are other defendants. If it is a joint family property, is only 1 or 2% cannot execute GPA, sale deed, gift.
All the cases that you, the father, and all children. If you are one of the son, there is
No.
seven different.
No, GPA for what?
GPA for all general purpose.
No, what is that purpose GPA said? Is it for YouTube, this thing? Where is that finding of the court? The plaintiff have established the prima facie case in their favor regarding the balance of money to discover. Immediately after the death, science of the plaintiff and defendant vested in them cannot be divested by mutation entry or GPA for the reason that there is nothing on record to show that plaintiff and the other defendants do not have the share in the fruits of the property. But to do the gift deed executed by the defendant number 7 instead of the defendant number 8. See, you have executed in a gift deed.
Just if you are independent.
Mutation entries have to show that name of the defendant number and but the defendant can transfer any question. See, all this issue has to be decided by the court. Suit is pending. In the meantime, if you alienate the property, will it not create third party interest? That is what that interim order. Injunction is not to create third party interest. It is a reasonable order.
The rejection. If that property belongs to them, it is not joint family property. They are in joint possession of the
That is true, Mr. Counsel. All point has to be decided, is it not? Now it is before the court, whether it is joint family property, it is your own property, whether GPA is there. Till disposal, not to alienate that property because you have admitted RTC is in your favor. At any time you can alienate. What is wrong in that order?
understanding was executing GPA that they are giving the property to me.
Al-
So GPA was executed.
Is it that is the understanding? Or that GPA has been taken by forcefully? All has to be decided in that final trial, is it not?
I'm coming from this property, my son can defend for 8.
Then you want to sell that property.
We are in that, we are not selling it, our property. We are in possession of the
Then you are
property.
not selling, that order will be there. What will be happen there? How it will cause any harm? There is no injunction.
Because we are the owners of the property. Because we are the property.
No, Mr. Counsel, court has not said you are not an owner. Court said that don't alienate that property till disposal of the suit.
That's why. Because I am the owner of the property, I cannot prevent it.
Now then you want to alienate that property.
My right. But I am not.
No. You are right. That is, you are claiming court has to decide, is it not?
That's there, but ownership is with the appellants.
I think it is
And-
reasonable order.
And there is no opportunity in the affiliate,
Yes.
financial affiliation, that we are doing some act of telling the problem. What they have stated,
Who?
like.
Hmm.
Application, affiliate of financial affiliation.
Yes. No, that I can modify and say that all the parties are not to create third party interest in all suit scheduled property. Not vacating, Mr. Furtherance of this order. E orderly, nimig matra directions ಇದೆ. I will give direction even plaintiff also.
Trying to do that person property from me.
Yes, issue
From
notice. Issue notice. Yes, Vishwanath. Hmm. Yes, Mr. Yes, at the request of the parties. It is matter of 19.
Number 43, MS Nagaraja for appellant.
Yes, Mr. Nagaraj, what is this?
Taking my application number 39.4.
Defendant appeal, suit for.
Injunction. Whether
Yes.
he's, this is not an activity. It's not division. See, he's claiming that if in first floor of the property, which is not in, for even everything, only is just as the point. Yes, my case. No, that the first instance, they have granted injunction on the default of filing a statement in 90 days. That followed the order, like, I pay them a parties.
Admittedly, he is in the position.
How does the court has found that really reasons so is not considered of the case.
Yes.
In place of 24 reasons for rejecting my application. 24. For consideration of the above facts, it is the scene that para 4 of the claim that it is stated to the date of partition is dated 2009. I think it's an example. The other showing the address for my 7th May Road, first class Gautam Nagar, Shiva. Same itself reflected in other parts of the painting. 5. We noted electricity state 8/11/2020. That's where this is also patient for here it shows that possession of the date of filing is just 3 days. After is the inconvenience for the other the court has not been considered. Number 39 court what how we what is possible?
Yes. Issue notice. Parties are directed to maintain status quo in respect of suit scheduled property till next date of hearing.
As of the
If you are there in the position, you continue.
Yes. 44, Dr. Babu Valle for appellant.
He is against the order.
No, this suit is filed by.
Appealing for the respondent number 1, I have filed the payment, my name is not.
Yeah,
Any of senior counsel has served a copy now.
yes.
May I request it for Monday?
Yes.
The intention order 2010,
Hmm.
with respect of the very same property against the vendor of this respondent. It seems that he filed a suit that the first respondent against his vendor, there is no right in the property and obtained the suit from the vendor. He did not execute the sale deed. Now he has filed the execution petition and he is seeking to execute the sale deed.
What is that you object?
The objector to his possession as the owner.
Maintain status quo.
may not be correct, I will place it before the court and kindly have it on Monday. Monday.
Till the status quo, because.
No, wait, what will happen till then? I have to hear it. Yes.
Yes, when you see in the page 90. The decree obtained by the against his vendor. That is the first respondent.
Page 19.
Page 90.
90. Yes.
This is not the petitioner's.
Permanent injunction.
Yes.
What is your sources of title?
Yes, sale it, registered sale it, April 98.
You have purchased in the year 1998.
98.
From whom?
From the original owner.
Owner.
And the second respondent is the vendor.
No, that injunction you have obtained
Yes,
against that Shivanna. Who is
Yes.
that? Who is that?
now he is the vendor of the present first
He is
respondent.
claiming that he is the owner of that property.
Yes.
That injunction has been in your favor. Yes. Then
He obtained a degree against the second respondent on the basis of the lead agreement of sale. There is a degree, expired degree. Now he has to print the execution.
now that Mr. Arika, he has a right to implead because admittedly there is an injunction showing that he is in the possession of that property. Person who are positioning that property has a right to be objector.
That the admission part of it, I don't agree.
No, that what you say about the decree passed.
That is fine, that is fine. Right. This is given.
Now that what is that stage in that? No, that I will grant. If nothing will happen till then.
Yes, fine. One is for not to eliminate. Other is I am not constructing. That they granted is that restraining land property.
No, that Mr. Not to construct, that means he is in the possession. Not to alienate is also that he is in the possession. You know.
No, not to alienate, will not
Not to alienate. When we will say that either he is in the possession or he is having a title. Not to construct anta yavaga helbeku anta andre. If he is in the position, he is trying to construct. This two is there. Then you, if you given that one kayal kottu innond kelta not to enter antandre, what is that?
My humble request is copies are given now. And his accommodation may not be.
Tomorrow,
may not be
yes.
unreasonable.
Yes, sir. No.
His accommodation. And what is going to happen till tomorrow?
No, Mr. Ariga, I am not passing any order.
Yes.
On the basis of the submission of the senior council, I think the crux of the matter is this much. It is nothing more than that.
Let me have this accommodation.
Yes.
And we come back to this.
Yes, Monday, nothing will, Monday if he is not considered.
Nalene happen. Senior council
Tomorrow.
request.
Otherwise, this matter can be disposed of.
Yeah,
That is the case. Only thing is that you have to verify and make use. I will show the director to show this. Yes.
File a KVA.
See, Ariga submitted that he has filed an caveat for which respondent?
Respondent number 1.
Respondent number 1. Office is directed to show his name. Release this matter tomorrow.
Yes.
Yes.
Venkatesa Prasad R for appellant, Guru Raj R.
Before the trial court, defendant, partition,
No, you are appearing for?
present apparent.
Then you are the appellant.
Yes, sir.
Yes, what you want time?
I'm for respondent. I'm so.
No, this is his appeal.
Yes,
You have to make
partition, yes. Good for partition.
it. Good
Partition.
Yes.
Item number 1 and 2, the plaintiff, that is the respondent, claims that it's actual property. We also admitted in our written statement.
This is a defendant appeal.
Yes,
Suit for partition,
partition.
possession. Now, what is that order? What is that relationship between that? There is no.
One is the son of one Degoda. Number 2 is the wife of the mother and one son are the appellant. Other son is the respondent.
What is the defense
That
you have taken in that suit?
there are 4 items. That one, we admit that item 1 and 2 are the accident. So far, item number 3 is concerned, it's the property that is granted to my mother, that is scope of appellant number 2.
And item number 4 is the granted property to chapter number 1. Apart from that, I treated the other two properties granted to the appellant, that is respondent and to his wife. So I made the submission to the land that those properties also be included for partition. But the court has come to the conclusion that sufficient argument. So can you come to Interim 21? Secretary. Interim 24. But DW1.
Yes.
But DW1 because that item of code is self-evident copy of itself. In order to substitute that, this he has not given any closure to convincing evidence to the court. Moreover, it was that there are already partition among item of 1 to 4 properties. But in order to substitute that, he has not raised any single piece of action before the court. DW has taken different conditions and he cannot order court at the same time. In the condition of debate number 1, if item number 4 property is the self-evident property cannot be accepted. So to substitute, documents are not produced by the advocate to appeal for the
Yes, we will admit it. Yes,
Yes, sir.
yes, heard, admit.
Let them stay, not to bother it.
Yes. Stay up. Drawing of final degree procedure. Let's see what that in partition suit. Appeal, it's a right. Now that only let them go ahead with that final degree proceedings, not to draw that final degree procedure. Yes. Or admit. Stay up. Drawing of final degree procedure. Yes.
It vacated the property. The date of vacating the defendant found that there was certain damage. He vacated because agreed with the parties that they sorted out whatever damage that was done and against the advance and advance plus 2.
Yes. Yes. Now, now that what is the finding of the trial court? Yes, heard. So what is stay up? It meant a degree dated 10th August 2022 passed by. It is sealed such and such Bangalore in OS number 1712 of 2019 in next state of hearing. Who is appearing for other side? Yes, anyone notice let them till next state of hearing. Yes.
Award I go for appellate. There are
You are a defendant. You are a defendant. No, no, defendant. Yes, that's one. First, we have to say that to whether what is your ranking in trial court. Yes. Yes. No, plaintiff is a landlord. Yes.
On
60. 40? 14. 2014.
And the last renewal, that was on February 2018.
No, what is the finding of that trial court? Why that order of,
Damages.
no, on what ground he has filed an ejection petition?
Yes, there was a small dispute in 2019.
Regarding payment of rent. On what ground you have filed an ejection suit?
I was ready in the beginning.
No, you are appearing for whom, sir? No, that's what. That's what I'm asking. Suit has been filed on the ground that there is an arrears of rent. Now we will see that what is the finding of that court.
What cases, I was ready and willing to make it premises, but they didn't. I issued in their list, I issued legal notice.
Now, in this case, you are already out.
I am not out. My items are inside and it's locked in.
No, that he's ready to give up. He's ready.
I issued legal notice, the last notice after.
Now he is ready to open that lock and you take it whatever you want, then finish it up. Defendant is directed to pay the arrears. Arrears of rent is due. ಆಯ್ತ್ರಿ $1,46,46,679 ಡ್ಯೂ ಇದೆ. He will deduct it from that advance and remaining will be paid. Settle that. See, is there any due? How much? How that calculation? Give that calculation how it is due for 7 lakhs.
Yes, 15,000 arrears of rent.
No. See, court itself has passed on a degree for arrears of 1,46,000. You can't go beyond that.
After that, there the damages also will not.
Damages 15,000 ರೂಪಾಯಿ ಇದೆ ಬಿಡಿ.
Per month. Per month. ಯಾವುದೇ ರೀತಿ ಕೀನ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿಲ್ಲ.
ಬಟ್ ಲಾಕ್ ಆಗಿದೆ.
ಇದ್ದಾರೆ ಬಟ್ ಅವರೆಲ್ಲ ಬೇರೆ ಕಡೆಯಿಂದ ಚೀಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸರ್. ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಆಯ್ತು 15,000 ರೂಪಾಯಿ ಅಂತ ಅಂದ್ರೆ ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು? 15,000 per month damages to the plaintiff for an illegal occupation of the service from the date of the suit. Finding ನೋಡೋಣ. Now that you have to pay that 1,46,000. That you have to pay as per that this thing. Then you give up that damages and open the key and let him go. One for all, it is settled mission. Otherwise, if I admit it, again this problem will arise. Now are you ready? Taking that 1.5 lakhs rupees, open the key, let him go. You want to get an instruction, you get that instruction from the parties. If it, no, you have to pay that 1,50,000, Mr. No.
I am ready to vacate, but they are not letting him go away. And they are asking damages.
No, ready to vacate anta ಹೇಳಿದ್ರೆ, have you given a notice to them?
Yes, sir. I notice that I am not and they are making it.
No. You said that I want to vacate. Have you given a notice to them that? ಯಾವತ್ತು ನೀವು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ? I am going to vacate. 2019 after that degree. After that degree, you forget, Mr. I'm not even asking him to calculate that dues regarding after degree. Just stick on to the degree. As for the degree itself, you have to pay 1,50,000 rupees for rent, damages. I'm asking him to give up the damages. If you are ready to pay 1,50,000 and ask his client, finish it. One case is over. Why are you dragging all these things? Are you ready to pay 1,50,000? Huh? Not orders if you are ready. Otherwise, I have to dismiss this case on merit. Then you will execute it. Huh? What is your instruction, Mr.? What is that advance amount?
No, my lord, no. Entire calculation date of filing.
I told after deducting that advance amount, he has to pay 1,46,000.
Yes.
You forget everything. Forget damages. Pay 1,50,000 rupees and no, that.
I declared on the same day, the next week, saying that I'm ready to vacate and
No, if you are not agreed for that proposal, then you submit an memo of calculation. Let him submit. If I satisfied, I will dismiss it. Let him execute it. That's all. Before going to that merit, on prima facie, this is my suggestion. If they are not agreed, then I will hear on merit. There is no problem for that. Yes. When do you want? Yes. Next week. Next week. That is the proposal, Mr. You also ask your party. Adrnary, client you party, you are not in. I am giving this suggestion. If both are agreed, then only. Otherwise, I will go on with that matter on merit. That's what I said. Or if both the parties are agreed for any other settlement also, it is welcome. If you are not agreed, this is the one more this thing. Then we will hear that matter on merit. If both has not agreed, both of them has to be come with that memo of calculation up to date. I have to see that memo of calculation. Then I will decide. Yes, next, what is your matter? Other ಏನಾಗಿದೆ degree?
Not the appropriate person.
ಅದಕ್ಕೆ wait. No, wait. What is the finding of the trial court regarding that issue? Then I will secure that records in your case. Yes. GPA is there. No. See, we'll see that records when filing that appeal itself. They should have mentioned that it is GPA. Ultimately, even he will, as an LR, he has come on record because now your father is no more. By the time of disposal of the suit, you are in this thing. The legal area has come on record. ಅದಕ್ಕೆಲ್ಲ ಡಿಫರೆಂಟ್ ಮೆಕಾನಿಸಮ್ ಇದೆ. ಅವ್ರು ಥ್ರೆಟ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೇಸ್ that is different. This is not relevant here. Here this case, yes, when do you want both of them? Yeah, though. Second matter, you are ready to vacate that. What about the dues?
usually after gives 11. It is other deposit against you. That again, because government is.
No, deposit. You give that memo of calculation, you also give that memo of calculation. If that memo of the calculation is correct, then you will grant some time by filing an affidavit, then finalize that. Already first, already month May ಕೊಡೋಣ ಇಲ್ಲ ಜೂನ್ಗೆ ಕೊಡೋಣ ದುಡ್ಡು ಹಳೆದಕ್ಕೆ ಏನ್ ಹೇಳ್ತೀರಾ ಅಂತ ಅವ್ರು ಕೇಳ್ತಿರೋದು ಅದ್ರ ನಾನ್ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕಲ್ರಿ you give that memo of calculation both of them. Yes, nimdu will post it on which date? Yes, serial number ಎಷ್ಟು ಇದೆ 47. The parties are directed to, I will just say that memo of calculation, understanding that we have to get an instruction regarding that settlement, directed to pay that file memo of calculation. Post this matter 19. Really, again, parties are directed to file a memo of calculation. Post this matter on 23rd. Yes.
49. For appellant, Chintan Chinnappa.
First is not there.
There is an idea to stay. Injunction. I had the injunction for 11 years. Not next.
We'll get time conference. Pass over or we'll have it next week.
I'm the respondent.
Yes, none appear for appellant. Use this matter next week.
Matter, serial number 50 adjourned, serial number 51, SV charge 3 for appellant, MP Geeta Devi.
Yes. Last occasion, this is the matter they have undertaken.
Time will not be argued the matter. This is where the earlier the coverage was upheld, but regarding the litigation, the matter was demanded.
Yes, yes. He said the senior will come. Pass over. Yes.
The matter.
2:30 I will, yes.
52, the Balakrishna Shastri for appellant, K. Chandranatha Ariga.
Balakrishna Shastri wants time. Yes. At the request of the parties, use this matter of 2 weeks. Yes.
53, K.V. Satish Chandra for appellant, connected matter, Ashmit Tegre, yes.
Why the connected matters notice is not put? Huh? 52, you want time? Yes, at the request of counsel for the appellant, 2 weeks. 53, could you? RFA craft, could you? RFA, could you? Paper file medical. Paper file medical. None appear. Use this matter of 2 weeks. Use this matter of 3 weeks.
54, the Ramesh for appellant, Dinesh Rao.
Yes, Mr.
23rd or 24th.
Yes, on 24th. 24th. The request of the parties. Illa, it's an hearing matter. Hearing along, hearing. Yes, it is there in the here. Order granted earlier is extended till next date of hearing.
55 adjourned. Passport matter. Number 7, Ramapat K for appellant, Narayana Swamy PM, S.J. Puranik.
Yes, what is your instruction regarding that? No, that you file it in a, no, you do one thing. You file along with memo as in a report after serving the copy to that other side, because they have to know what is their case. Government advocate appearing for government advocate. No, yes, yes, government advocate submitted that. As per the directions of this code, ADLR has conducted in a survey. The report will be submitted by next week after serving a copy to other side. Yes. That's why I said that government advocate, because they will contacted the government. Yes, yes, yes. They will directly come to that government advocate because they don't know where they have to. Before I ask the government advocate. Yes. Next week, our Merlin, our then presence better. Next, if you have any dispute regarding that report, you have to file an objection. Then we will see if the presence is required. I will ask the government advocate. Yeah.
Serial number 24, Desai Rajendra for appellant.
Yes. No, that's yes. Yes. Yeah. Hmm. Hmm. What is that finding of the court? Yes, you take out notice and hand summons also. Any date if you serve it and move before the court. Issue notice. Listen. Appellant is permitted to take out hand summons to the respondent. Yes. Yes, MS Nagraj. Yes, you have that judgment. Do that, we will dispose of. Or the other serial number. Yes. Just give brief facts. Hmm.
63,007.
Yes.
Spending.
Yes.
They were supposed to cover 16, they did not cover.
Yes.
They took the difference of the matter of spending.
Yes. 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 2016, that is 45A order. Yes. Yes.
We have placed that material of record.
Yes.
They have to distribute it.
Which is that paragraph you are reading? Yes. 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 Yes.
Not in the nature of the field. Yes, I see.
Yes. Yes.
It's acceptable. All distance, so the extent even if they are based. Second, we also Indeed, sections and section 2 shall decide.
Yes, on very same point, it has been answered. Yes. Appeal is filed by Corporation. The section 82, subclass 2 of Employees State Insurance Act, challenging order passed by State Insurance Court in ESI application number 4 of 2016 on 30th March 2019, whereby appeal filed by the respondent has been allowed. Application filed by respondent has been allowed. The matter is remitted back to the corporation for first consideration. The case of the appellant is that government by notification dated 16/3/2011 extended ESI Act to education institution. In view of the above, the education institution, that is respondent number herein, as covered under the ESI Act, they have to submit a return every year. Since they have failed to apply the provisions of ESI Act, respondent, by exercising the power under section 45A, has initiated the proceedings, has issued notice to the respondent on 7/11/2014. They have given more than 5 opportunity to the respondent to produce that relevant records as per the provisions of ESI Act. Since they have failed to produce the same, on the basis of the material available on the basis of the materials available with the corporation, corporation has passed an order under section 45A of the Act. Being agreed by the same, respondent herein has filed an application before the ESI court under section 75 of the Act in ESI application 4 of 2016. The State Insurance Court has allowed that application and remanded the matter. Being agreed by the same, the corporation is before this court. So and so learned appearing for the corporation has contended that government by order dated 16/3/2011 has extended the ESI Act to education institution. From the date, education institution, that is respondent number herein, has covered under the Act. Since they have not submitted any report, the corporation has issued a notice. Corporation has initiated the proceedings under section 45A of the Act and issued notice to respondent on 7/11/2014. They have given more than 5 opportunity to the respondent to produce relevant records. Since they have failed to produce the same, the corporation has passed an order under section 45A. She further contended that the respondent has challenged the order passed under 45A before this court, before that ESI court. Under section 75 of the Act, the ESI court has an original jurisdiction, has an all power to examine the documents produced by the parties and pass an order. the ESI court, instead of exercising the power under section 45 of the Act, 75 of the Act, has error in remanding the matter to the corporation for fresh consideration. In support of his contention, she has relied on judgment of this court, Supreme Court, judgment of Apex Court in case this another court. That's what. ALR. Between Escort, MS Escort Limited versus Regional Director. Respondent has served unrepresented. Sought a learned counsel for appellant. Government, by notification, by order dated 16/3/2011, notification, yes, notification, extended ESI Act to education institution. Since respondent has not filed any return as per that ESI Act, for they have not paid the contribution to that corporation. The corporation has initiated the proceedings under section 45A of the Act and issued a notice to the respondent. In spite of giving in a sufficient opportunity, the respondent has not submitted the relevant records, and that they have not. You have given a notice to submit in a records or submit in a contribution. Yes. They have issued a notice calling upon the respondent to why the corporation should not be determining the contribution amount in spite of giving a sufficient opportunity. The respondent has not responded. Hence, they have passed an order under section 45A. That order has been challenged by the respondent by filing an application before ESI court under section 75 of the Act. The application has been registered as ESI application 4 of 2016. As for section 75, the ESI court has to decide that matter as an original jurisdiction. This court, in case of MS Escort Limited Supra, has held as follows. Pagely 3610 mark ಮಾಡಿದೆ. It is appears to us that submission of so and so ಅಲ್ಲಿಂದ regarding that must decided the question mark ಮಾಡಿದೆ. First next. It is very clear from the above said. It is very clear from section 75 and also from the judgment of this court that ESI court has the original jurisdiction to decide all questions arises in respect of contributions. The tribunal ESI court, instead of deciding that dispute between the parties, it has remanded the matter to the corporation for fresh consideration by impugn order dated 30th March 2019. The impugn order is passed contrary to section 75 of the Act. The ESI court has failed to exercise the power under section 75 of the Act. Under these circumstances, the matter requires to be remitted back to the ESI court for fresh consideration in terms of section 75 of the Act. Accordingly, the appeal is allowed. Order dated 30th March 2019 is set aside the matter is remitted back to the PSI court to reconsider the matter afresh after taking note of judgment of this court in so and so. Yes. Yes, you are not there. Yes. In both appeal. The counsel for the appellant has filed a memo seeking leave of this court to withdraw this appeal. The memo is taken on record. The appeal is dismissed as withdrawn. All pending appeals have shared.
Still about 53, Your Honor.
Yes.
All are, there is a partition, so Your Honor. All are daughters of all are about 60 to 70 years.
United. No, none appear. It is urgent.
49 into.
Next week. Next week. ಬರತ್ತೆ ಅದು 2 weeks ಅಂತ ಬರ್ದ್ಬಿಟ್ಟಿದೀವಿ. ಆಯ್ತು next week ಮಾಡಿ. Yes. In fact, other side ಇದ್ರ
ಅವರು cars ಹೋಗಿ ಲಾಟಿ ಇರ್ತಾರೆ.
let us see, that is also posted. Then we'll see that next time. Yes.
Next week. In part, more dependent I was not. Give it that office. Other than give it the office money. So fine. 46. Now, I would copy someone and give it again. Serious.
ತೊಂಬತ್ತಕ್ಕೆ ಯಾರಿಗೆ ಮಾಡಲ್ಲ
Yeah, it's not- ಇಲ್ಲ.
Court officer? Court officer? Court officer?
ಹೇಳಿ ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು, ಏನಾಯ್ತು?
ಒಂದು ನಿಮಿಷ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೋಗಿದೆ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಸರಿ ಸರ್, ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ. ಓಕೆ.
Yes.
Means you in 521.
Bench matter. Interlocutory application matter, serial number 1, Angana Basava B. Patil for petitioner, Rana Basappa M. Bapu Gowda Siddappa. Kalburgi bench matter.
Yes, Mr.
Angana Basava B. Patil for petitioner, Charana Basappa M. Patil, Bapu Gowda Siddappa. Sir, Samsung SMA name upload ಮಾಡಿ sir. Sir, Samsung.
None appears. It is not up to it.
Principal bench matter, on to our matter, number 17. We are Balaraj for appellant.
Yes, Mr. What is the, who has passed the degree? Then the family court acts. Hmm. No, now that your case has been transferred to the family court, order is passed by that family court. No, earlier it is passed by that family court. Then you have filed an RFA. Office has not raised an objection. No, you see that family court act. You have to file that because it is under special act. It has to be converted as an MA. File a memo. Yes, yes. Learned Counsel for appellant has filed a memo seeking conversion of this RFA into the MFA. Memo is taken on record. This regular first appeal is converted as MFA. Statistics office is directed to convert this RFA into MFA for a statistics purpose. RFA is disposed of. Yes.
Number 33.
Put it. So,
Number 38. Ajay JN for appellant.
just give just brief facts. Yes.
Synopsis.
Yes. Yes. Now that Shakuntala is the absolute owner of this property. What is the property's description?
It starts at page number 15.
Yes. Yes.
India Marana Shastra Patra, Mysore Manala Devi Mangala Gopi Highway Intercity Road number 60 Vasana Highway Gate R Raja Murani Mangala Sumaru Gandharkan was vice mission the Asha Putra Parasect India Guru Marana Shastra number ನಾನು ಸೇರಿ ಇಂದಿನ ಹೆಣ್ಣಿದ್ದು ಮೊದಲನೇ ಮಗಳಾದ ಸರೋಜಿನಿ ಈ ಹಿಂದೆ ಹೊಂದಿರುತ್ತಾರೆ ಎರಡನೇ ಅಕ್ಕನಾದ ಆ ಸರೋಜಿನಿಯವರು ದಿನಾಂಕ ಬಂಧಿಸಿರುತ್ತಾರೆ ನಾನು ನನ್ನ ತಂದೆಗೆ ಮೂರನೇ ಮಗಳು ನಾನು ನನ್ನ ಅಕ್ಕ ಆ ಸರೋಜಿನಿ ಜೀವದಲ್ಲಿದ್ದಾಗ ನಾವಿಬ್ಬರು ಒಟ್ಟಿಗೆ ಮೇಲ್ಕಂಡ ನನ್ನ ಅಕ್ಕನ ಹೆಸರಿನಿಂದ ಮೇಲ್ಕಂಡ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ಈಗ ನಾನು ಒಬ್ಬಳೇ ಮನೆಯಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿದ್ದೇನೆ ನನ್ನ ತಂದೆ
She is the yes.
She is got it. She and her sister will yes. Then they give the entire history of what
Yes,
their
yes.
relationship,
No,
their
that
nature.
property description is there in that.
Yes, and schedule page number 20, page number 22, page number 22 schedule. Property schedule is there, and in the petition we have given the complete schedule of all the assets because the bill has 3 assets.
Yes.
So the complete assets are all there in the schedule, which cannot be found at page number 3 of the bill.
Yes.
So schedule A is only
Yes,
Schedule B is fixed deposit in the bank.
yes.
Schedule C is fixed deposit in the. Fixed deposit, someplace, schedule B is pension amount, syndicate.
All this has been executed through will.
All this is, all of that is mentioned in the will.
All of mentioned, yes.
He was a retired school teacher. So in Mysore, so every day evening they have a Bhagavad Gita session. So all the old women gather there and they have that ashram. That is the reason. PDR there for the detail legally, not will find that at page number 18 of this. Page number 18 of this savings bank account.
Yes, yes.
Page number 18 savings bank account there.
Yes.
Page number 19 FDR detail.
Yes.
And then execute the yard so all access
Where is which paragraph?
the executor never to find the executor's name.
Para 11. Yes.
Who's the
Executor.
the appellant?
Yes. Upper line. Client petitioner has filed this appeal under section 299 of Hindu Succession Act, Indian Section Act 1925, read with section 104 of CPC. Thereby challenging order dated 7th August 2021, passed by 5th Additional District Judge Mysore in P&SC 35 of 2020, whereby rejected the petition filed by the appellant. The facts of the case are that Timothy Death or Shakuntala, the absolute owner of scheduled property. She has executed bill on 20th/11/2020. Other 20th/1/2020. Is it? Yes. In favor of? She has executed a will in favor of that
As well as Usha Kiran Charitable Trust.
Rama Chandra Ashram
Ramachandra Ashram.
and
And Usha Kiran Charitable Trust.
Usha Kiran Charitable Trust, Mysore, and nominated the appellant A. Umashankar as the executor. The will is produced as Exhibit P2. The executor has filed the petition under Section 276 of Indian Succession Act before 5th Additional District Judge Mysore, seeking grant of probate. To establish his case, he has examined 2 witnesses and produced 15 documents. As per the provisions of the Act, respondent has taken a paper publication. PW2, Lokesh one of the witnesses to that will. He has been examined has taken a paper publication. PW2 Lokesh has, who is the one of the witness to the will, has been examined. On consideration of material available on record, the P&SC court has rejected that petition. Being agreed by the same, petitioner is before this court. So and so learned counsel appearing for petitioner has contended that as for Exhibit P2 will, petitioner PW1 Umashankar, he is the executor. PW2 MS Lokesh is one of the witness to that will. He has been examined. He has filed an affidavit and he has categorically deposed that the will is executed in his presence, and he has signed the will. The executor has signed the will. The testator has signed the will in his presence. Contrary to that, material available on records, the P&SC court error in held that there is no whisper in the evidence of PW2 that he has signed the will in the presence of testator. Hence, he sought for allowing that appeal. Or the learned counsel for the appellant. The case of the appellant petitioner is that late Srimati Shakuntala or executed an unregistered will on 20th 1/2020 in favor of so and so, and the applicant has been appointed as an executor. This will has been executed in presence of two witnesses. One is, what is that other witness? Shrikantaya BS. Shrikantaya BS. The another witness is MS Lokesh. The Lokesh has been examined as PW2. Where is his affidavit you have shown?
Page number 10, page number 10 in paper.
Yes, this affidavit filed by PW2 has been produced in his affidavit, paragraph 5. He has deposed paragraph 5, 6 and 7 has been explained. But P&S court has failed to consider this affidavit. The finding given by P&S court is contrary to that material available on records. Hence, matter requires to be hence appeal has to be allowed. Matter has to be sent it back to that, remitted back to that P&S court to give one more opportunity to that petitioner appellant to examine the PW2. Accordingly, the appeal is allowed. Order dated so and so is set aside. The matter is remitted back to the P&S court, that is 5th Additional District Judge Mysore, to reconsider that matter afresh after giving an opportunity to the petitioner. Okay, yes. Office is directed to return the trial court records forthwith. Yes, one day you are the party. Yes. Yes. The petitioner appellant is directed to appear before the P&S court on 6th March without any further notice. The P&S court is directed to dispose of the petition not later than 4 months from the date of appearance of. Yes. 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 Yes, you just give the brief facts, then I will. Yes. Memo for. Yes, written argument. Yes. Yes, yes. 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 Yes.
Not later. You said all the rules have been
Yes.
So here you have got EDA, this order also passed in the that is also and earlier you got ES application to 1988, which came to be not disposed by the.
I can recollect that earlier order regarding that applicability has been confirmed. Where is that? Now, therefore, you give that, Mr. Counsel, give that brief facts from the beginning. Then we can go. See, first, when that order has been passed. Under, 15th January 1998. No, I am asking that first order under 45A. Yes. That is the only one order that has not been set aside. Therefore, you come from that chronologically. First, you can.
First order was passed in the year 9/5/1988.
9/5/1988.
1988. Period was 27/1/1985, September 1987.
1987 to
January 27/1/1988 to 30th September 1987. That is the concern.
Yes.
First 45 order was issued on 9/5/1998.
Yes.
That order was impugned in EI 43 of 1988.
Yes.
That matter was upheld in the order. The PD was 15/1/1998.
15/1/1998.
That was challenged in MFA 1139 of 1998.
Yes.
Wherein the matter was remanded back to the ESI court.
Yeah.
ESI court again took up the matter EI 43 of 1988 on 6/2/2001. What confirmed two issues. One issue was regarding the coverage, regarding the quantum, the remanded.
Where is that order?
That order is marked as Annex A1.
See the records. Yes. What is the date?
6/2/2001. I put a flag on that. Exhibit A1. Finish the narration here.
Yes.
The notes,
Yes.
After this was remanded, after this order, the fresh order was passed by the ESI Corporation on 11/2/2000. That specifically
11.
Challenge penalty, ESI orders of penalty. Only passed. This was challenged before EI court in 13/4/2002. Was disposed of. Then MFA was filed in 23/6/2004.
That is present MFA.
This matter was dismissed on 9/11/2005.
No, that 34 of 2002, when that order has been passed by ESI court.
That is 2003.
11,
12/2003.
2003. Again, MFA.
MFA 2364 of 2004.
2364 of 2004.
Dismissed on 9/11/2005.
Yes.
SLB is filed, appeal
Yes.
1316 of 2007.
Hmm.
Matter was remanded back. Sir, employees were not heard.
Yes.
The matter was remanded back.
To that ESI court. Hmm.
ESI court is not-
Yes. Now that regarding this point, preliminary point, it is not covered. It has been answered under that exhibit A1. We will come to that exhibit A1 first. 6th February 2001. 6th February 2001. You read that order portion. You have the copy. Hmm. Hmm. Hmm.
So the case is remitted back to the living conclusion. The salary for the employees and this is the application is allowed. This application is not really
Back to the respondent to levy that contribution, taking into the consideration. See, direction is
Levy contribution. Levy contribution. Coverage.
not coverage issue is not left open. That is not permissible for that corporation to decide that, because this has been confirmed somewhere. It has been decided.
Earlier paragraph.
Yes.
Specific issue.
Stop as a result. There cannot be any doubt that field stop will come within the definition of the employee. One there. Relying upon that, where is page
26, I have it. All the. Para 11.
wait. It has been remanded only in respect of the determination of the this thing, not for that coverage. Hmm.
Coverage is not made. Coverage is because it has been given to the establishment. Because we have the issue in present case is not within field stop.
That is what that. See, they said field stop is coming within the definition of the employee. Hmm. Hmm.
Because we want the shop. It's not a factory. As they not they are dependent on the ESI. But that they want to issue.
Yes.
Employees of the factories of establishment which are situated in the area where the problems of the capital before that it not ended. Whereas the notification of was also dated 1977 government of Karnataka exempted the certain others of employees employed in factories and establishment under the control of state government only competition of employees, state insurance 1948.
No, which is under the control of the state government. Yours is under the control of state. Now, what is the meaning of control of the state government? It is under the state government entities. NGFO, Itara factory, they are all that under the control of the state government. They are that not all factories. No. What is the meaning of establishment under the control of the state government from the operation of the employees? under the control of the state government ಅಂತಂದ್ರೆ it is in state government entities, Mr. For you, there is no control over that. See, government has a share. See, like that.
My submission to you was that it's ESI Act, not the act, because it's established, not concluding, not whatever the country is, not from the Sami government. But at least wherever the practice of the Sami government, there is.
No, first thing is, it is not applicable to that central. They said state government, controlling of the state government. It is, you are saying that it is central government. Second thing is, you are distributing that work of the central government. It is not under control. You are an independent. ನಿಮಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಕೊಟ್ಟು ಕೆಲಸ ಮಾಡಿಸಿದಾಗ ಅಷ್ಟೇ. No, that is not bitter. No, establishment control under that government and what is that? Control under the government and the government has any shares in that. It is not that whoever doing that work of the government is not control under the government. It is like that. State government which gives any aid to that institution, they are under the control. Private education institution cannot be. That is how that control under the government and the government has any control for all activities. This is not applicable to you. No, this is that first order 2001 2000 page 18. Yes. Against this, then they have passed an order under 45A. Against that, you have filed an appeal. Where is that second order on 11/12/2003? Okay. Where is that? 11/12/2003. Have you produced in that appeal memo or is there in that appeal memo? Let us see that what is the discussion. Yes, yes. Now we'll now that we will come to that 2003. Yes. The applicant files, yes. Whether that applicant proves that applicant company is not covered under the ESI Act, whether the applicant has proved that income so and so, in view of so and so. Number one, negative. Yes. 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 Every contribution taken sadly taken for as what the
order determining the contribution of 39, 31 employees and assume wages are one. Another concept for the applicant subject that the applicant has not engaged more than 8 employees apart from field staff who are not required to report Bangalore. So the applicant responsibility is not covered under the policy of PSI Act. It is also protected that it is not manufacturing any products. So it is not the practice as defined in section 2(1)(2) of the PSI Act. So their main condition is that since they have complied with employees, they are not covered. This condition has to be mitigated for the simple reason that they are consider this point.
That is what that. It has already been.
He also considered the conditions of the regarding the manufacturing activity, considering for labor that the activities do not come within only of the word shop as it is mentioned. In a notification also get that it is not excluded that the field staff were not allocated on the leave. They are being paid. In fact, the applicant had produced wages paid to field staff as per executive. Therefore, show that they are employed for wages. Therefore, taking into consideration regarding this and also have to be considered. This is also stated in that case. Noted that the names of the employees who get one year resident, which is about 600.
No, therefore, that contention is not left open. The earlier proceedings itself is concluded. You are not challenged, but taking an advantage. No, that is what that in the second round of litigation court said. Court has not decided that issue. Since it is already decided, then you are not challenged. Therefore, I am holding that they are an employee. Yes. That is what, that is not the tenor of that Supreme Court direction. No. They are a beneficiary. Why they have to be heard and say that they'll say that we are not covered? See, they have been implemented because you are going to deny. Therefore, they can establish their right. They are not supporting you. That is not the intention. If that is, see, yes. See, when already held that they are an employee, should they say that no, we cannot be held an employee? Therefore, we have to be implemented. That is not the tenor of the Supreme Court. Supreme Court, see why ultimately beneficiary is that employee, therefore impede them. No, sometimes corporation cannot be contested. In all cases, they are contesting. They may say that no, ultimately who is affected? It will that employee. That has been decided, Mr. Now that is there any other dispute? Yes, we have somewhere we have read that Supreme Court statement. We have that. Kantipur and the other side, I think they have not appeared. You are taking notice in that. Now that all that cases that in that railways also you are appearing, then I will direct you to take notice. Yes. Yes, I will direct him to serve a copy also.
I was going through these records.
Yes, no, we read last time.
Last time we did. Young people do that. You know, the appeals to say the matter demanded.
Yes.
We are not the orders. The High Court has also the ESA courts and demand matter to the ESA certificate workers instead of some of them we are representative can decide the matter afresh. That is what will happen. Decide the matter after
Yes, afresh. No, afresh in respect of your claim. You have not claimed in respect of that regarding not covered because that has been confirmed. You have not challenged. Therefore, the stage only in respect of other aspect has to be considered afresh. That is what that. Yes, Supreme Court said afresh. Afresh means. No, afresh means earlier order is not certified. Yes. No, see, no, it will go back to that. No, afresh means it will no, will say that. No, it cannot be go back to 45A order they have passed second time. Supreme Court has not set aside. They could have set aside that also because you have not decided in respect of the coverage. Supreme Court has not decided. They have also not decided because it is already concluded. That order is there. They could have set aside that second time 45A order and say that you decide both in respect of coverage. Supreme Court has not find fault with that their order.
And the merit power not to determine under section 45A in the first instance because no records not in the records and because it only other cases. Subsequently, what
Now that let the ESI court decide that point. ESI court decide that whether it is ESI court for second round, they have not decided because earlier it is already decided. Supreme Court said, pass an order afresh. See, you may not be considered, but as argued in the morning, ESI court has to consider, it is open for the ESI court to consider all these aspects. Now that the purpose of asking to implead, since they have taken a contention that this employee is not covered, give an opportunity to them to establish. Otherwise, they need not be a party. If that.
Question my lord is that the matter was went up to the Supreme Court.
No. They have challenged 11/12/2003 order.
2045 order was.
Your 45 order has been challenged.
Order was passed. That was come up, that came up to the ESI court, EA 34, MFA 2364, then a civil appeal 1316. And that in this 45A order, specifically it is mentioned.
No, after Supreme Court has been set aside and sent it back to ESI court, has they decided regarding that applicability of that act, now that impugn order?
No, that is not true. Only the determination has been confirmed whether,
The entire LOT.
Yes. Now, what is that?
The entire exercise was being was the second 40.
Yes.
They are raising this issue.
Yes.
But the ESI corporation not challenging it. ESI court order.
That order has been set aside by the Supreme Court.
The order is aside.
Yes.
The order was being remanded.
No, by set aside that remained back.
It did not come back to the ESI court. The ESI court is ESI court.
No. Therefore, I said the
No, they
purpose is
can't.
instead of sending back to you, ESI court can decide all the aspects, including that, because morning you have said that it is in original jurisdiction, all the litigations. See, otherwise, just because not impleading that employees, implead them and send it back.
Very well, my lord.
Why they have to be impleaded? Because if they tomorrow you say that it is not covered, then they are affected. Therefore, otherwise that tenor of the Supreme Court judgment to implead will not be.
My lord, should we kindly see the order? There is no order on merits other than their request that we have not complied with. Earlier, the fresh judgment came from Supreme Court.
Like that only Supreme Court orders.
Consider a fresh.
Yes.
First leg is that the coverage was not challenged by them. It stood covered. That is the first point. And therefore, what went on came to this order. First order still holds good. Then, my lord, the second aspect, if you were to consider the second aspect, that is the first argument. In that event, my lord, the coverage is not still open. It's only the determination. That is not the ESI.
No, for determination, what is the role of that employee? Why they have to be made a party?
Question is that, my lord, how much the payment have to be made or not? My lord,
No.
They are contesting. Field staff, we don't have to pay the amount.
No, now that there is an order that they have covered. After coverage, only thing is that determination.
Field staff, whether they should be incorporated into numbers or not.
No,
Whether,
that
my lord, they are saying now,
yes.
if they are covered, then yesterday covered. Field staff will not cover. We are saying field staff, what's that?
No, now that's what that we can have any arguments and have any material to show that field staff is also covered in view of the judgment. That has to be decided by that ESI court. No, now that if that is the case, when Supreme Court has directed that the ESI court has to be decided all these aspects.
The question is,
No, they have not decided regarding the applicabilities of the act. No, if they have determined, then it need not be sent it back.
Sorry.
Where is that, this thing? Only determination they have done. Applicability. Now that, by understanding that Supreme Court judgment, is it that point has been left open or not?
To with my
Our-
submission, my lord, because that issue did not even go before the authority.
Yes.
It's already concluded. And once we are not, if they given up the challenge, is it open for them to challenge again? But have they taken the trial again? How can they remand?
No, that even if you see that first order is not clear. They said the entire order is set aside.
You respect.
Yes. No, they said.
The order very clearly says that
Yes.
the court says it
No,
cannot
that-
be dispute at least to say from March 85 onwards, all the 20. It is so the applicant is covered.
Now the complication has been created by the apex court order.
Apex court
Now
order.
that,
What we have to see, Milord, the partition suit, an analogy to partition suit, the right has been determined, quantum is being shares have to be apportioned. That is where the dispute is. Similarly, even here, Milord, coverage is stand count. Now, whether which employees have to be paid contribution is what they are now trying to say. What they are saying, the field employees are not again. They are saying.
no, field employees has to be given the contribution is there. Why that Supreme Court has asked them to implead? If that understood of that court is that, yes, field employees is already covered, then only thing is to be determination is correct or not.
At that point of time, this where court has said employees have to be heard, and therefore the court they have taken advantage of it and started came to their way. Now the question is, my lord, that also has been considered here by this court has considered that the ESA court hearing.
Yes, that is what that we have to say. If they are considered.
Point that is considered and here, my lord, particularly exhibit A1, it says.
Now that after the remand, is there any finding regarding that?
Literally, there is not say coverage and contribution.
Yes.
Exhibit A1.
No. Now we are saying that what is the order of the Supreme Court? Tenor of the order, if you see that implead them, because you may be concluded, but they have not left for that. In each cases, they are taking that contention, saying that it is not covered. In that ESI court said that no, it is already decided. What is that High Court order in MFA? When it is dismissed and confirmed that order? Which you have challenged before the Supreme Court.
2634 of 2004.
Oh, 2364 of 2004. In all stage, he has gone agitating that point. You have that SLP copy, Mr. SLP appeal memo, have you taken any such? Yes.
Especially in petitions, Captain, not kind. Government is also taken the input on the everything set aside. I am not appreciated that we say try to the and establish only when the number of complaints is 20 or more and those employees answer the distribution of the employee content is a kind of thing. It's what our government.
No, whether you have taken that field employees is not covered.
That is a lot of only when the challenge is not not when that time not when I've taken into the
There is that two, 3, 6, 4. Now that issue number 1 is also framed. What is that answer? Where is that? Now that after remand, the ESI court has understood that it has to be Supreme Court direction is to consider this point. So what is that answer? Yes. 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 Where is that? Read. Yes. Yes. Yes.
For declaration that the applicant is not coverable, that is coverable, nothing is said. The applicant members of an order of restraining the demand notice commencing from 1988. The issue which was framed in the said case was whether the applicant proves that the applicant is not coverable in the PSI. After discussing the evidence given by the applicant, it was held that the first of the applicant will come into the implication of the employee act. But held that the carrying activity from the workshop. As per the investigation, government of Karnataka, present applicant released statement salaries paid to the each of the employees, also salaries paid to the field staff. In paragraph 11 of the order, is held that the statement showing the salary paid to the employees to indicate that the employee process were living less than 1,600 rupees per month, 40 paid state regular state wage. Also not with regard to the field staff, it was held that the statement released and the applicant the following process for 9 resident 1,600 per month during the following periods. These are the ones that reason. And basically, the work statement is that there were 28 points of the established. The department's mentioned that the applicant had engaged 38 points of not believed that according to the decision of the text of the reported in sources from the basic operations. Also, finding was correct that the total number of persons employed by the Indian was 20. Most 20 persons were employees as dependent on section 29 of the PSI. Right from the month of March 2019. This was further held that irrespective of whether the strength was less than rupees depended without the section of the PSI. And yes, the thing is not on the PSI. This not issue number 2. PSI code after setting aside the employment of this demanded matter to PSI the direction section that the salary paid to corporate employees applicant is mentioned above after giving notice to the applicant past. This order has not been communicated. Again, no is something that whatever the order passed by PSI, the Supreme Court was never considered.
No, that has been answered. Supreme Court said, see, your case is that it is not covered. That has been taken into the Supreme Court. Supreme Court to reconsider, no, afresh antandre, no, afresh means, no, no, that is what, no, Supreme Court said, you have given a finding that it is already considered. You consider that aspect also, again, whether it is true that you are already considered or not. Again, they have given a finding that yes, it is. No, that is correct. That is correct. It is already covered. It is already. No, Mr. Shastri, what is that? In the second round also, ESI court said it is already decided that you have taken to the Supreme Court. What the decision you have made, it is already covered. You have to re-examine. As he rightly held, it is already covered. They have re-examined and held that yes, already decided. Therefore, yes. That is what that.
Yes, taken earlier.
You are not understanding what on the basis of the earlier order, second round, they said it is already decided. Supreme Court has sent it back. You re-verify. They have not said that you have to reconsider that whether it is covered or not. They said that yes, already there is a decision that they have not challenged. Therefore, I am holding that. That is what the Supreme Court has not directed to reconsider whether it is covered or not. They consider afresh from the stage 45A order has passed on second time. Yes. Therefore, again and again they are saying that that is the correct version they have taken by the TC. Yes.
These are originally applicated since year 1976. The applicant is not able to fertilize. There is almost field staff working in the different states. According to the bill, field staff will not report for duty until but there is demand.
Yes, there is no specific direction from the Supreme Court. Reconsider that issue, which is already finalized. No, it's nothing but after everything is closed, I am reopening. No, afresh in respect of that case itself. See, no, that is not this.
Requirement like is act, but 20 employees is required to cover under the ESI. That is not that's a demand.
No, otherwise Supreme Court. That is true. No, according to you, no. Field workers is removed. You are not covered on 9. But the field workers has covered is already. Yes, I will consider your arguments. Yes. That's all. Yes, madam. Yes.
Employee leave. We start illegal something. I pay directly wherever they are working.
No, your case is that this issue is already concluded, or then if I answer that, then I am reopening that. Tomorrow, if they are challenged that High Court has now that if I decide on the basis that the field employees are covered by definition, then it is opportunity for them to challenge this. Other, I have to say that this issue is already closed.
This issue is already
They have not challenged that.
have not challenged.
To determination.
Yes, we examined the issue.
Yes.
And then now problem would arise, but now we are looking at the aspect, even 85 to 89 is the they have not produced any records. They say they produced only wage register and then salary register.
Yes.
Rest of the lectures talk about they have detail. They are litigating for 60,
Yes.
40 years we are litigating. It will not be available, not make any good for anybody. Not is that who is the loser? Ask this question to listen.
Yes.
The employees were denied the benefits of the year. It is the company.
Yes.
Who, the
Now, what you
employee-
have done that best judgment assessment?
Once the judgment is done, and the purpose of this act is to see for defined salary, distant, ceiling, salary of safety, are hardly 1,600. Today it is 21,000, 25,000. So many employees are denied the social welfare legislation.
No, now that once it is held that it is covered, determination is not challenging. You said that determination is right. You are not disputing regarding the determination. No, that is there any irregularities in determination you have?
Okay. But we have never paid that much. But even
But you have not produced any documents.
documents cost what
Now that we come to that, see regarding that issue, what is the decision of the TSI court? Yes. Thousand 600. No, now that how that no that ground is still available to you. Therefore, I am asking to argue on the. Show me that is what. Now that is the only point I have to decide here. Nothing else. Issues. Whether the applicant proves that interim order passed by the respondent is without jurisdiction. Yes, that is the this thing. 45A order. Yes, now you come to the issue number 2. Issue number 2. Yes. Yes, yes.
Not challenged. According to section 15 of the Act, all the employees in factories or establishments to which this Act applies shall be insured. The Act is aimed at confirming benefits to employees in case of sickness, disability, and employment injury. Section 38 is a mandatory provision. Section 39 provides for the payment of the issue contributions. Contributions payable under the Act in respect of the employee shall comprise contribution payable by the employer and contribution payable by the employee and the same shall be paid to the corporation. According to the definition of the Yes, I every employee should send it to the contribution to the farm right. Allowing the office of the sellers and allocate the contribution amount within 42 days of the contribution. The body of the Act state that the principal employee should pay contribution in respect of the employee that they are directly employed by him or employed by the immediate employer or immediate employer of ESA inspectors and legal obligation. That is something particular stated in the employer. If any information is required, you can call upon the employer to publish information. If the returns are not filed and that the information required by ESA is not published by the employer, corporation may, on the basis of information available to determine the amount of contribution payable in respect of the employee or the employer deserving of which not being heard. An order is possible leaving sufficient proof to claim. Corporation is something determine such order as earlier something manually. In the present case, the order of section 23 has been passed as per the legal basis 11 to 2022 every day from ESA being heard. The order said that the various the directions given by ESA in case of number 43 and 28, the employer was given explained his objections contained in the regard of the payment of economy. The applicant was represented to receive the release of the he said he did not produce vouchers, cash books, and others. He said that spirit of the the personal hearing was given on 6/7/2021. On that day, he released his original attendance or they said not be produced. When his attendance was 1486, 3987, base result for the period 57, 3987. He did not produce voucher, cash book, matters, balance sheets, saying that we are not aware. The respondent observed that those are very necessary to ascertain that the employer had waited only one things registered that there were no other other books, vouchers, etc. The applicant was provided further opportunity on 7/1/2022. On that day, decided release a uniform of ESA officer that the vouchers, cash books, of accounts and balance sheets for the period from the regular implementation were not available. Observing that the ESA was ordered to accordingly, however, the establishment with effect to 1/3/85 had not been appealed. The ESA not undertake the first application not been available. As the authority to determine the amount of contribution, finding the ability to determine the amount of contribution payable in for the period from 3987 or as against September 2021. An order that will say amount shall be paid to the data order lot will be 6% of 1998 interest 12% from 2010 interest 15% from 1994 almost data payment. We even payable and set amount shall be recovered and provided section. Set order was not used.
Yes, that in terms of that 45 years, there is no illegalities. We have not produced the voucher, cash book, ledger, balance sheet. Left, when you have not submitted a return, then that
sufficient. They are not getting the thousands, seeing units to not that described by the ESA for 1,600 rupees. That has been brought in the notice of
no, therefore, to establish that voucher, cash book,
all documents are required. Or here they want they are not made direct employees.
what is the documents which has been required to prove that they are paying that salaries?
They have directly employed field staff. They have employed. That's not denied.
No, now that chapter is over. Now that for a determination of contribution.
Payments, it should show as X amount of those the accounting every month salaries paid. we are not retaining it. Then,
Yes, that issue.
they can make out.
No, ledger, you can write anything. No, see, when you are studying, we know that lecturers has been paid 500 rupees and that taken that note as an paid at 5,000 for the temporary lecturers that time. That is how that they can be managed. That's what I'm saying. To prove that payment,
Seasonal.
no, anytime, even if they work one day, there should be any records to show that how you have paid, except ledger. Then, when you are filing in a returns, you have to give all expenditure. This is the amount I have paid, therefore it is not taxable. You are all companies, you have to maintain without filing in a returns. It cannot be. All this now they will not maintain all these things.
The dispute was fresh. And they raised the dispute fresh in 1985-87. Of course, notice in 87, period is 85-87. Within 5 years, they all had on the records.
Then it is a second round. No, see, when that opportunity has been not given, you could have produced in that proceedings under 75. That would be the part of that. But the 75 is that original jurisdiction, they can decide all these things. Yes, that's all I would conclude. Well, this appeal is filed by applicant under section 82 of Employees State Insurance Act 1948, challenging order dated 10th August 2012, passed by Employees State Insurance, passed by insurance quota though. What is insurance quota? Yes, insurance code. No, that power has been given to that but it is an insurance code only. Insurance code in ESI application number 34 of 2002, whereby application has been rejected. Brief facts of the case are that for the convenience, parties are referred to the ranking as per the ESI code. The applicant is in a company incorporated under the Indian Companies Act, having its register office at number 277, Patheri Road, Madras, and regional office at number 3/2, Chennai. Yes, Chennai. Mittal Tower, B Wing, 3rd floor, MG Road, Bangalore. Applicant is engaged in the distribution of fertilizer on behalf of the Government of India in the regional office at Bangalore. The further case of the applicant that there are only 9 employees, excluding that executive. The applicant is not in a factory as defined under section 2, subclass 2, 12 of ESI Act. The further case of the applicant that they have engaged the field staff who worked in a different place. They are not required to report at the Bangalore, and they are not the employee for the purpose of coverage. Next para. Since the applicant has not submitted a contribution, the ESI inspector inspected the applicant establishment and made a report to the regional officer. On the basis of the said report of the ESI inspector, the order under section 48A of the Act came to be passed on 9/5/1988. 45A. Subsequently, ESI Corporation initiated recovery proceedings. Being agreed by order passed by the corporation in the section 48A of the Act, 45A of the Act, the applicant has challenged the same before ESI court in ESI number 43 of 1988. Being agreed by the same, the ESI court has dismissed that application. Against that order, the applicant has filed an MFA before this court, MFA 1139 of 1998. This court by order dated 24/11/1999 has allowed that appeal, remitted the matter to that ESI court for fresh disposal in accordance with law. After the matter remanded by this court, after hearing both the sides, ESI court has passed an order on 6/2/2021 has set aside that order passed by the corporation and remitted matter back to that corporation for fresh consideration. After remand, the corporation, after giving an appeal to parties, has passed an order under section 45A of the Act the date, second term 45A order. Yes, 11/2/2002. Yes, 2000. Yes. Yes, being agreed by the same. The applicant has filed an appeal before ESI court. Application before ESI court in application number 34 of 2002, 11/2/2000. 11/12/2003, the application has been dismissed. ಎಲ್ಲಿದೆ part? 2003 ಏನ್ partly allowed ಅಂದ್ರೆ yes, that has confirmed.
It is part of.
Yes. Yes.
Which means he has.
Yes. On 11/12/2003, the quantum was modified. Being agreed by the same, the applicant has filed an appeal before this court in MFA 2364 of 2004. What is that order passed under 2364? Flag it. No? Idi the justice. Yeah, Justice Anand Bhairav. This court confirmed the order passed by ESI court. Yes, by order dated 9th November 2005, this court has confirmed the order passed by the ESI court. Being approved by order passed by this court on 9th November 2005, the applicant has filed. You Supreme Court ಅಲ್ಲಿ ಹೋಗಬಹುದು ಅಷ್ಟು ದುಡ್ಡನ್ನೇ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಕೊಡಬಹುದು. Now, what about that other establishment?
Notice has been issued. Notice has been issued. They are waiting for this order. That is what you
Where is this? In that event, now what has happened, 45 order, limitation has come. Actually, they are saved.
No, now they cannot because after 5. And that is no, that's what I am asking that. No, why you are worried about only this amount? I thought that there be something beyond that. Yes. Against that, filed an SLP before the Apex Court in SLP 1316 of 2007. Is it right? Civil appeal. Civil appeal number 1316 2007. Appeal is allowed. The matter is remitted back to the ESI court for first consideration. After that matter has been remitted, the ESI court has passed the order that is impugned in this 1316 of 2007. That is not SLP, civil appeal. Civil appeal. Yes, it is converted as yes. Civil appeal. Yes. After remand, yes. The ESI court has passed the order that is 10th August 2012 that is impugned in this petition. So and so learned counsel appearing for applicant has contended that. Ravindran, your name will be shown. Yes. Ravindran. Yes, yes. Shastri, what written? Is it?
Stop coming.
Stops coming. Yes, he stopped coming. Now you are taking over the top. Yes. Ravindranath. Ravindranath K. Learned Council appearing for the appellant. Yes. Contended that the applicant establishment is not covered under ESI Act. They are engaged only 9 employees, excluding that executives. The applicant have engaged that field staff who are working different place. They are not required to report at Bangalore. Hence, they are not an employee for the purpose of coverage. The ESI court error in held that the staff employees has covered under the act and they are an employee of that applicant company. He further contended that the apex court in civil appeal number 1316 of 2007 disposed of 27/2010 has remitted the matter back to the ESI court to reconsider the matter afresh. Includes the applicability of the act to the applicant company. The ESI court has not decided this aspect of the matter. Only on the earlier order passed by the ESI court in no, that has been decided in 2001 in appeal number 43 of 1988 on 6/2/2001. Yes, EI number 6/2/2001 has held that the staff employees is also covered under the act. This finding of the ESI court is contrary to directions given by apex court. He further contended that while determination of contribution amount the applicant has produced the ledger before register, wage register and attended register before that authority, and they have taken a specific contention that they have paid the salary of rupees more than 1,600 per month. Since their salary is more than 600 per month, they are not covered under. That's what that. Yes, their wages is more than 1,600, therefore they are not covered. That is your case. Yes, they are not covered under that act. In spite of they are producing that sufficient material, the authority has passed an order under section 45A of the act has held that the field employees are covered under the act and the salary paid them is less than 1,600. They have taken 700, 800. This is contrary to the material available on record. The order passed under section 45A of the Act is contrary to provisions of section 44 of the Act. Hence, he sought for allowing that appeal. 880. Yes. Yes. For contra, Geeta Devi, learned counsel appearing for corporation, has contended that issue in respect of applicability of ESI Act is concluded by order of ESI court in EP number 43 of 88. ESI, sorry. ESI application short form is the EA not one. ESI is the full form. I want that any short form is there like that is that, yes. Now, application, is there any only word is A? Yes. ESI application number. Therefore, application. Yes. Oh, then that is yes. ESI application number 43 of 88 on 6th February 2001. The issue regarding the applicability of the Act in respect of field stops has been held. That Act is applicable. And in that order, the matter is remitted back to the authority only for determination of contribution. That order is attained finality. The corporation, the applicant has not challenged the same before any court of law. Hence, he contended that now it is not open for the applicant to argue that the staff field employees are not covered. She further contended that after the matter has been remanded as per order dated 6th February 2001, the authority has passed an order under 45A, has determined the contribution. That order has been challenged before the TSI court and before this court, and it has set aside and case is remanded. No, what I said, remanded back. I said regarding that staff employees is what is that? Coverage ಬಗ್ಗೆ held, they held. That you see that is the point for her. See, there cannot be any doubt that field staff will come within the definition of the word employee. No, that is, as a result, there cannot be any doubt that field staff will come within the definition of the word employee. That is the finding. Himself has admitted that salary has been paid for the Bangalore office. That goes to show that there has been a relationship of the employees and the employees between the applicant and the field staff. As a result, no, that is what now we have argued, and see, order portion is in respect of the dirt finding, it is confirmed. Matter is limited only for the purpose of determination. Contribution. Determination of contribution. Only either a direction set aside and remit. If that would be the case, you have in a case. This only the person has been given a breathing for her to argue. Matter as yes, yes, that is the crux of the matter. Yes. Yes, this court has confirmed the same. The matter has been taken to the apex court. The apex court has remitted the matter to the ESI court for first consideration. Since no, that is what that. After that, you have passed a fresh 45 order at the after the remand, they have passed an order. Yes, that has been challenged before this court. Instead of saying that, I briefly said that challenge before this court, it has been confirmed. That has been challenged before the apex court. Matter has been remitted back to the ESI court for afresh consideration of afresh only in respect of our argument, only in respect of determination of contribution, since applicability of the act is already confirmed. Therefore, the ESI court has rightly passed an order and held that the act is applicable to that of employees. Field stop. She further contended that while determining the contribution under section 45A, the applicant, except producing wage register and attendance register, no other documents has been produced to show that he has paid that 1,600 rupees in favor of the employees. Even he has not produced IT returns submitted to the income tax department. Therefore, the appellant, therefore the authority, on the basis of the material available on records, has passed an best judgment assessment under section 45A of the Act. In support of his case, she has relied on a judgment. Supreme Court. Best judgment assessment and the 45A order, when they have not submitted a returns as per section 44, you can pass an order. 1994 supplement.
SEC supplementary 580.
Yes. $1997, 1997 9 SEC 71 another wages. Adana. Yes. 1997.
The SEC.
Page
number 57. Item number 5.
Yes, 1997. Free SEC supplement. So on. Hence, he sought for dismissal of the appeal. That is your main contention is that it is not decided. If I want to decide that aspect, then your judgment has to be relied. I'm saying that it is already concluded. Therefore, it is not reopened by judgment of Supreme Court. Heard the learned counsel for the parties. Whereas the impugn order and original records. It is not in dispute. The applicant is in a company incorporated under Indian Companies Act, having its registered office at Chennai and having in a regional office at Bangalore. It is also not in dispute that the applicant has engaged field stop the preliminary contention raised by field, they have also engaged the field stop. And further, it is not, they have engaged the field stop. The further case of the main contention raised by the applicants that field stop are not covered under the ESI Act. This issue has been decided by ESI Court in ESI application number 43 of 88 on 6th February 2001. Categorically given a finding that field stops will come within the definition of the word employee. In that order, even though matter has been remitted back to the ESI authority in respect of issue coverage of the field employees is concerned, it is confirmed. The matter is remitted only for determination of contribution. The order passed by ESI Court on 6th February 2001 the order portion is extracted below. The order portion extracted below. This order has not been challenged by the applicant. This attained finality. Therefore, now it is not open to the applicant to argue that field employees is not covered under the Act. After the order passed, after the remand order passed by the ESI Court on 6th February 2001, the authority, after giving an opportunity to the parties, has passed order under section 45A on Second order is on 98 Allah. 11/2/2002. Yes. This next para. This order has been challenged before the ESI court in ESI appeal number 34 of 2002. Application. ESI application 34 of 2002. The ESI court has passed an order on 11/12/2003 and has given a categorical finding that in respect of applicability of the act to stop field stop is concerned. This has already been decided by the ESI court in order dated 6th February 2011 and it 2001 it attained finality. It's quantum use, yes. No, I'm just saying that. Yes. That order has been challenged before this court. The same has been confirmed. Against that, the appellant has filed an appeal before that Supreme Court in civil appeal number 1316 of 2007. The apex court, yes, has passed following order. Extract Mulberry. Matter is remitted back to the ESI court to decide the matter afresh after affording an opportunity of hearing to that parties concerned. Since issue in respect of coverage of field staff is concerned, it is already decided by ESI court and that has attained finality. Only in respect of determination of contribution, the ESI court has to be reconsidered afresh after giving an opportunity to all the parties. After remand by the apex court, the ESI court has passed the impugn order, that is on 10th August 2012. Now, the point which has to be considered by the ESI court is only in respect of determination of contribution. Now, the point has to be considered is whether order passed under section 48A, 45A, dated 11/2/2002 is in terms of provisions of the Act. It is not in dispute the applicant has not submitted their returns as per section 44 of the Act. That is not dispute because you are saying that they are not, they are within that 9 members. No. Then they have initiated they can initiate it only you have not submitted the returns. That is what that section 45 says. Therefore, I am saying why they have voluntarily started. They have not submitted the returns as per section 44 of the Act.
Also contribution, they have not paid.
And they have also not paid contribution to that employee. When that, under that situation, ESI inspector has inspected that applicant establishment and submitted in a report to the ESI regional office. On the basis of that report, the authority has initiated the proceedings under section 45A. They are given a notice to the applicant. Applicant has represented through his advocate. Ravi Asegda is an advocate. That I know that. That's what he is the Ravi. Yes, yes. Yes, I know that he has practiced here and yes. No, I thought there is no reference that advocate Ravi Asegda they have mentioned. Has he represented as in a capacity as an advocate or therefore I am as an advocate? Yes. Ravi Asegda. Advocate, oh, yes, as an advocate, appear before the authority on behalf of the applicant. He has produced wage register and attendance register. The applicant has not produced any other documents except these two documents. They have not produced the voucher, cash book, ledger, balance sheet. Even they have not produced IT returns filed by that company. Alala, that is your, yes, I will come to that. IT return submitted to the income tax department. Authority cannot be decided the payment of wages to that employee only on the basis of attendant register and wage register. Since no other relevant records has been produced, they have no other alternative. They have to pass an order under section 45A. Since they have passed just judgment assessment, the section 45A of the Act, the said order has been passed after giving an opportunity to the applicants and his representative. There is no error in the order passed by authority. Therefore, there is no illegalities in the order passed by the authority. Therefore, there is no error in order passed by ESI court in ESI application 34 of 2002 on 10th August 2012. Accordingly, the appeal is dismissed. Yes. Yes, the judgment is passed.
And in morning, I give a citation in this court case. Give a number. Year wrong, my lord, passed on 1986 ILR.
That I think we are referring that which is that copy you have given?
This court case.
No, that what is the citation? It is there in that. You have, from where you have got that copy? Is it SCC online, it is, ಅದರಲ್ಲಿ mention ಇದೆ SCC ಅಂತ. ಅದು ಕೊಡಿ ಅವರಿಗೆ judgment reference. That it is with the court officer, Allah, he will communicate. Yes. Now, what they will write, I have given that judgment. Is there any citation mentioned there? They will write other. Yes. It is there. Now, this judgment, ILR 1986 Karnataka. Otherwise, there is no any other citation here. Nothing. Yes, even our stenographer. Yes, we'll do. Yes, yes. Now you are only the colleagues or any other is there for Shastri semester? No, any other colleagues are there? You are the one. Yes. Now you are taken over that Shastri's officer. Ravi has shifted there. He is Dharwad. Yes. Yeah. Oh, yes, sir.
Passport matter serial number 33. Tanvir Pasha, yes, for appellate. Shanti Bhushan.
Notice. Accordingly dispose of being satisfied with showing the affidavit. What is Angela? Shanti Bhushan will not subsequently take notice in there. None appear for the appellant. Shanti Bhushan, learned assistant solicitor general, has submitted that. Copy is not served. The learned counsel for the appellant is directed to serve one set of copies on learned assistant solicitor general. Yes.
ವರ್ಷ